heard. God bless the great state of Ohio and this honorable court. You may be seated.
All right, good morning. Today's date is December 19th, 2025. It's the morning docket of Lawrence County Municipal Court. I'm acting Judge Brian Cremines. First group of cases we're going to call are the reviews. So when you hear your name called, come down to the table on your right and we'll review your case.
Adam Bailey, Darren Korn, Marissa Floyd, Ian Lewis, Ashley Baines, Dustin Phelps, Kenneth Roberts.
Review hearing, anything like that?
All right, Adam Bailey. All right, this is the State of Ohio versus Adam Bailey, CRB 21859, A and B, TRD 143740, CRB 20304, thank you, CRB 12480, CRB 12528, A, B, and C, CRA 121016, and CRB 1017. All right, it's a good report, Mr. Bailey, on your treatment. There's still a whole lot of things outstanding on your case, but I'm more concerned about your treatment than I am with those things at this point. So we'll set you a new review hearing.
What do you say, more things outstanding?
Through January 30th. At 9 a.m. for review. Thank you. Darren Korn. Darren L. Korn. All right, this is State of Ohio versus Darren L. Korn, CRB 2496 A and B, CRB 23761. Mr. Korn was decided to be here at 9 a.m. for review. He has failed to appear. That'll be a bench warrant issue. Christopher Collins.
Yes, sir. He also has an arraignment.
All right, we'll do your arraignment first, and then we'll do your review, Mr. Collins.
Do you want Christopher Collins? Yeah.
All right, this is State of Ohio versus Christopher Collins, CRB 25561 A and B. All right, in CRB 25561A, Mr. Collins, what we're going to do, and we're a little out of order on this, but what we're going to do is I'm going to go through your arraignment on this matter. So I will read you the charge, the maximum penalties involved associated with that charge, and then I'm going to ask you for a plea. You can enter pleas of guilty, not guilty, or no contest. Guilty plea means you're making a complete admission that you committed the offense charged. A no contest plea means you're not admitting that you committed the offense charged, but you're not contesting the facts surrounding that offense. And if I believe that there'd be enough evidence to find you guilty, I can. And a not guilty plea preserves all of your rights before the court. You're not making any admissions. You have the right to remain silent. We're recording everything in here today. If you say something that is against your interest, it can be used against you. You have the right to have an attorney. If you can't afford an attorney, I can appoint one to represent you at no cost to you. You have the right to reasonable bail, and you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. You feel like you understood my explanation of your rights?
Yes, sir.
Okay. In CRB 25561A, it's alleged on or about August 28th, 2025, you did with purpose to deprive Walmart, the owner of property or services, knowingly obtain or exert control over said property or services by deception, That's an alleged violation of Ohio Revised Code Section 2913-0283. Theft, that's a misdemeanor of the first degree. Maximum penalty on that is up to 6 months in jail and up to $1,000 fine. In the B case, it's alleged on or about August 28, 2025, you have recklessly enter or remain on the land or premises of another as to which notice against unauthorized access or presence is given by actual communication to the offender or in a manner prescribed by law, or by posting in a manner reasonably calculated to come to the attention of potential intruders, or by fencing or other enclosed manifestly designated to restrict access. That's an alleged violation of Ohio Revised Code Section 2911.2183, criminal trespass, that's a misdemeanor of the fourth degree. Maximum penalty on that is up to 30 days in jail and up to a $250 fine. How do you wish to plead?
No contest.
Okay, so you enter a no contest plea, you're not admitting that you committed the violation, but you're not contesting it either. Is that what you want to do?
I'm not really understanding what to do right here.
Okay, I'm going to enter a not guilty plea then on your behalf. Do you have money to hire a lawyer?
No, sir.
Are you working currently?
Not right at the moment, right now.
All right, I'm going to appoint Attorney Sean Stratton to represent you.
Yeah, I did not know this was coming about right here.
Your Honor?
Mr. Stratton, this is a M1 Walmart theft
I had no idea
and
this was coming about right here.
Okay.
a trespassing, which I would presume without looking at it, that means there was another prior Walmart theft. I will let Mr. Collins, since he appeared here today, sign a $2,000 OR bond.
Your Honor, will he need to be fingerprinted?
You'll need to go to the jail for fingerprinting.
Don't leave, I'll bring you a copy of this.
And Mr. Stratton, how far out would you want to go before you came back?
Your Honor, let's just into the new year. I've got my list of dates here. You tell me which date and I'll see if it.
How about the 16th of January?
That'll work, Your Honor. We'll step outside.
That'll be a pretrial at 10 a.m.
All right, thank you, Your Honor.
And then, well, hang on, we got to do a review. We've got,
Yeah.
we also got to review on an old case.
Yeah.
All right, in case number TRC 24-1976 A, B, and C. You've done some community service on that. I'm going to go ahead and keep these together, so I'll set you back on the 23rd as well for review.
23rd or
16th
16th? Hey, okay, I'll write it down, yes.
for review. And I'm going to do that at 10 a.m. as well. I'll put it with the pretrial, so we'll do a pretrial on review.
All right, thank you, Your Honor.
Thank you. Marissa Floyd. Marissa Floyd. This is State of Ohio versus Marissa Floyd, PRD 241486. Ms. Floyd was cited to be here at 9 a.m. She has failed to appear. There'll be a bench warrant issue. Ian Lewis. This is State of Ohio versus Ian Lewis, PRC 25360 A, B, and C, and PRD 25704. On the 25360, doesn't look like Mr. Lewis has done anything. And then on the 25704, doesn't look like you've done anything either.
Yes, I have. I live in the state of Kentucky, and I do.
Your Honor, if I may, Mr. Major advised me this morning he had some community service to turn in.
Okay.
It was not on letterhead, so we did not accept it, but we gave him the right paperwork to get it, so he can turn it in.
Okay. All right, Mr. Lewis, I'm going to set you back for January 30th at 9 a.m. for review.
Thank you.
Thank you. Ashley Mays, the state of Ohio versus Ashley Mays, CRB 23-517. And Ms. Mays, you made some payments, it looks like last payment was November the 10th. You have a payment today? Okay, how much are you paying?
$20.
$20. All right, I'm gonna set you back on January 30th. We'll review at 9 a.m. Dustin Phelps. This is State of Ohio, Dustin Phelps. State of Ohio versus Dustin Phelps, TRC 15-720, CRA 15-835. Mr. Phelps has failed to appear. It's 9:51 a.m. There'll be a bench warrant issued. Mr. Roberts?
Yes, sir.
All right, this is State of Ohio versus Kenneth Roberts, CRB 24-582 and CRB 23-142. On the 582 case, it looks like you've got 30 hours of community service and you still owe fines and court costs. And looks like you made a payment on the CRB case just a couple of days ago, so I'll set you back as well for January 30th.
Made a payment today too.
Okay. That'll be at 9 a.m. for the
What day?
January 30th.
Thank you.
Thank you.
James Sarton, Amber Spears, Alexis Smith, Michelle Sturgill, Mark Wells, Cindy Wood, Ron Witherell, Sarah Woods, Brittany Woodman.
James Sarton, the State of Ohio versus James Sarton, TRC 24-897, ABC. Mr. Sarton, you still owe 24 hours of community service, but you've done a substantial amount, and you still owe $860 on your fine. I'm going to set you back for January 30th for review.
Thank you.
Amber Spears, State of Ohio versus Amber Spears, TRC 24-2254. Got a payment on December 1st. Looks like your community service is finished, but you still owe $515.
Yes.
You can, if you want to work some more community service, you can continue working that off on community service.
I'm gonna bring a payment in probably Monday. I get paid today, but I've got to go to the bank, and we've been working 12s and 14s, so I can't run it down here today.
I'll set you for review on January 30th at 9 a.m.
Did you say January 30th?
Yes, ma'am.
Thank you.
Thank you. The quicker you get that paid off, you won't have to come back.
Yes, I know.
All right, Alexis Smith. Alexis Smith.
Yeah, I'm here.
This is State of Ohio versus Alexis Smith, TRC 19-3668 AMB.
I'm here.
I hear you. And Ms. Smith is here via Zoom today. All right, that's a good report. Ms. Smith, I'm going to set you back as well on January 30th. That'll be a
I'm sorry, I can't really hear you.
I'm setting you back for review on January 30th at 9 a.m. It was a good report.
All right, thank you.
Thank you.
Thank you, Your Honor.
Bye.
This is State of Ohio versus Michelle Sturgill.
She's on Zoom.
I see Ms. Sturgill.
Yes, sir.
Via Zoom here today. This is CRB 24589. Looks like Ms. Sturgill made a payment on December 5th. You still owe, looks like you're down to $119.33, Ms. Sturgill.
Yes, sir.
If you get that paid off or you work it off on community service, you won't have to come back.
Yes, sir.
I'm gonna set you for review January 30th at 9 a.m.
All right, thank you.
Thank you. Mark Wells. So State of Ohio versus Mark Wells, CRA 2753, PRC 2014, A, B, and C, PRC 171273. All right, on the first case, it looks like your community service is done, and you're down to $295. And on the 12 case, looks like you're down to $159.50 left on it. Have a payment today?
Yeah, 10.
All right. Well, I'll set you back for January 30th if you would either pay it off or show up and do a little community service. You could be done with this and not have to appear. I mean, if it were me, I'd try to get it done, but you're making progress, so I'll let you keep going as long as you want to do it, but you have to keep coming back. So,
All right.
really old cases, so.
Yeah, thank you.
All right, thank you. Cindy Wood?
Your Honor, I believe she's in custody.
Well, it looks like on December 8th, she was sentenced to 30 days jail.
They do not have her listed on our jail list, right?
They're going to check and see if she is in custody.
Okay, we'll pass this matter and call it a little later in the docket. Ron Woodrow. So State of Ohio versus Ron Woodrow, TRC 164698, A, B, and C, CRB 14844, A and B, CRB 131151. All right, that's an excellent report, Mr. Witherell.
Thank you, Your Honor.
There's still a lot of outstanding stuff here, but I'm more concerned with your treatment and you treating and getting yourself in a much better situation so that you can do this. So I'll go ahead and set you back for January 30th for review. Sarah Woods? The State of Ohio versus Sarah Woods, CRB 21686, CRB 22326. All right, Ms. Woods, that's another good report.
Thank you.
Looks like on the first case you have $595 left, and on the 22-326 case, you go $600 and 30 hours of community service, but as I told the last gentleman, I'm more interested in making sure you get your treatment than I am.
I'm working on getting the community service done too. I just finished, I just completed felony probation, so I'm gonna have more time to focus on this.
Who was your judge on that case?
Judge Ballard.
Okay. All right. All right, see you back January 30th.
All right, thank you.
9 a.m. Brittany Workman. All right, State of Ohio versus Brittany Workman, CRB 1946. Ms. Workman, there was a payment on November 18th, and it looks like you did some 6 hours of community service back in October. You still have 24 hours of community service left, and you owe $580.
I turned in a paper today. He's got to call and verify it for the community service. And then I
When they finished her case, she turned it in 15 days, and I didn't have time to do the math.
but I also have a $50 payment too.
Well, here's what I'm going to do. I'm going to set you back for January 30th. However, once Mr. Cooper updates that, that may close your case.
Okay.
If it does, he will reach out to you.
Okay.
And I'll try to tell her.
Yeah, I'll call her.
Next week, in the middle of the week, I'll let her know. Wednesday, I'll let her know. Tuesday or Wednesday, I'll let her know what we're going on.
Thank you, Ms. Workman.
Thank you.
Not really involved.
All right, State of Ohio versus Cindy Woods, 25678. Okay. Correct, and it was, they put it on for a hearing on today's date.
She was just scheduled to be released on the 7th of January.
Okay, well, I'm going to put her on then for Monday.
Okay.
Yes,
Okay.
and I would expect her to be here at that time.
Yes, sir. Okay.
All right, thank you. All right, next group of cases we're going to call our arraignments. It's first appearances on new charges. When you hear your name called, come down to the table on your right, my left, and we will go through the charge and the maximum penalties associated with that charge. Once we go through it, I will be asking you for a plea. You can enter a plea of either guilty, not guilty, or no contest. If you enter a plea of guilty, you're making a complete admission you committed the offense charged. If you enter a no contest plea, you're not admitting that you committed the offense charged, but you're not contesting the facts surrounding it either, and I can enter a guilty plea based upon that. And if you're unsure of what to do, you should enter a not guilty plea because it will preserve all of your rights before the court. You have the following rights. You have the right to remain silent. We are recording everything in here today, and if you say something to me that is not in your interest or is against something that you maybe shouldn't say on the case, the state of Ohio can then use that against you at a later date. You have the right to have an attorney. If you can't afford an attorney and qualify, I can appoint an attorney to represent you at no cost to you. You have the right to have reasonable bail set in your case, and you have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. First arraignment.
State of Ohio versus Hallie Russell, case number CRB 25-800.
All right, this is State of Ohio versus Hallie Russell, CRB 25-800. Ms. Russell has appeared here today and is being handed her charge. All right, Ms. Russell, it's alleged that on or about December 15th, 2025, you did, without privilege to do so, and with purpose to prevent, obstruct, or delay the performance by a public official of an authorized act within the public official capacity, hampered or impeded a public official in the performance of a public official's lawful duties. That's an alleged violation of Ohio Revised Code Section 2921.31A, obstructing official business. It's a misdemeanor of the second degree. Misdemeanors of the second degree carry a maximum penalty of up to 90 days in jail and up to a $750 fine. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty plea. Do you have money to hire an attorney? Are you working?
Yeah.
Are you paid hourly?
Yeah,
What are you paid hourly?
minimum wage. I work at Wendy's in Parkerville.
Okay, how many hours do you get?
Roughly 32 to 38.
Okay, I'll find you qualified. I'm going to appoint Attorney Luke Steyer to represent you. I'm going to let you sign a $2,000 OR bond. You're going to have to go to the jail, present to the jail for fingerprinting. And Mr. Steyer, how about how far out would you want to go before we come back?
I've had a couple days just to open up in January, so I'm gonna look at my calendar if I may, Your Honor. 9th, would that work?
January 9th would be fine. So I'll set it for a free trial at 10 a.m. January 9th. And Ms. Russell, you'll have to go to the jail and get fingerprinted. It's part of it, I guess, at this point, but it would be easier if we had the availability to do it here, but we don't be in the jail and have that.
Okay, thank you.
Thank you.
Thank you.
State of Ohio versus Holly Fields, case number CRD 25801.
All right, this is State of Ohio versus Holly Fields, CRD 25801. Ms. Fields is alleged that on or about December 12, 2025 in Fayette Township, that you being the owner, keeper, or harborer of a nuisance dog, except when a dog is lawfully engaged in hunting and accompanied by the owner, keeper, harborer, or handler of the dog, the owner, keeper, or harborer of any dog shall fail at any time to do any of the following, do either of the following in violation of section 955.22C of the Ohio Revised Code. Dogs running at large, that's a minor misdemeanor. The maximum penalty on a minor misdemeanor is a $150 fine and court costs. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty plea. This is a minor misdemeanor, and so you're not in jeopardy of going to jail on this. It's a non-jailable offense, so you're not entitled to a court-appointed attorney for that, based upon it being a minor misdemeanor. But what we would do is we'll just set you a trial, and you'd be able to hire your own attorney if you wish, or resolve it that day.
Okay.
So I'm going to set you for a trial on January.
Yeah, I wasn't sure how it would all work.
I'm sorry?
I said I wasn't sure how it would all work, but.
I'm going to set you for a trial on January 12th.
Okay.
And that'll be at noon. And I'll let you sign a $1,000 signature bond. And where this is a minor misdemeanor, you do not need to go get fingerprinted.
Okay. Okay.
State of Ohio versus Cody Mead, case number TRC 253047, A, B, C, and D.
This is State of Ohio versus Cody Mead, TRC 253047, A, B, C, and D. Mr. Mead, it's alleged that on or about December 13th, 2025 in Fayette Township, that you were operating a motor vehicle while under the influence of alcohol, drug abuse, or a combination thereof, and that you refused the chemical test with prior convictions in 2022 and 2023. This is the third offense. That's an alleged violation of Ohio Revised Code 4511-1981 and 4511.1982. Those are unclassified misdemeanors. The maximum penalty on that is the maximum penalty on that is up to a year in jail, a $2,750 fine, up to a 10-year license suspension, and forfeiture if the vehicle is registered to you. The minimum penalty on that is either 60 days jail or 30 days of jail and up to 110 days home confinement up to a year. A $850 fine and a 2-year license suspension and forfeiture. How do you wish to plead?
Not guilty.
I'll accept your not guilty plea. Do you have money to hire an attorney?
I don't.
All right, I'm going to appoint Mr. Steiger to represent you. I'm familiar with your indigency from other cases, so I know you qualify. You've appeared here today on your own, and so I'll let you sign a $2,000 OR bond in the matter. You're going to have to go to the jail to get fingerprinted. There's going to be a fingerprint order. And Mr. Steiger, I don't know if you were aware, this is a third offense.
I didn't hear anything about the case.
It's a third offense OVI with a refusal.
Is there a test score already available, or are we waiting for a test?
It was a refusal.
Okay. If we could set this on the 9th like we did the other, that'd be a good day for it, probably. So
I'll set this on January 9th for pre-trial, 10 a.m.
State of Ohio versus Bruce Ward, case number CRB 15268, CRB 11435, CRB 101087.
All right, this is State of Ohio versus Bruce Ward, CRB 15268, CRB 11435, CRB 1087. Mr. Ward is present here today. Matter is set as an arraignment. It looks like Mr. Ward is alleged that on or about December 15th, 2025, he failed to appear for a reason.
Yes, sir. I was snowed in and couldn't get out.
Okay, I will call the warrant. Looks like you've got on the CRB 15268, you've still got 52 hours of community service and you owe $863. I don't see any new community service on that case since September 10th of 2018. On the 11435, you owe $1,002. There's no payment since 2011. And on the 1087 case, no new community service, but the community service is finished, and you owe $42, but it looks like you made your last payment was, well, it's been a long time.
Yes,
You have
sir.
a payment today?
Yes, sir.
How much you paying?
I've got 15, sir. $15.
Well, I'm going to go ahead and tell you, these cases have been open way too long. I mean, you know, some of these cases are more than a decade old.
Yes, sir.
I mean, do you have any intentions of completing them?
Yes, sir. I ain't got driver's license, so I don't drive. But I'm going through counseling and stuff at Hopewell.
Okay.
And I just got a new thing from Hopewell, and I have the lady's card information. Like if I can't make it, they're going to help me get to get my community service and stuff done. And if something happens like it did Monday where I can't make it to court, she wanted me to ask about being able to do the Skype thing through her office.
If it's through them, they can do that, but you will need to contact the court, but, and I'm encouraged that are going to at least help you get to do your community service and things, and once you've worked your community service off, you can then start working your fines off as well if you wish, the community service.
Okay.
So I'll set you back for a new review at 9 a.m. on January 30th.
State of Ohio, Joshua Lee Turner, case number CRC
Thank you, sir.
25781, CRC 25625, A and B.
All right, this is State of Ohio versus Joshua Lee Turner, 25781, PRC 25625, A and B. All right, in the 25781, all right, Mr. Turner, it's alleged on or about November 22nd, 2025, you did in Sims Township, it's alleged you did knowingly cause or attempt to cause physical harm to Megan Turner, a family or household member, violation of section 2919.25A of the Ohio Revised Code. That's domestic violence as a misdemeanor of the first degree. Misdemeanors of the first degree carry a maximum penalty of up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
Oh, I'm sorry, Your Honor, this is the first I've even hearing about this. Not guilty.
Except you're not guilty plea. Are you working?
No, I'm off work dealing with another case right now. I have a lawyer though.
Okay, so you've already got an attorney?
Yes, JT Holt.
Okay, I'm going to hire your attorney on that. You've appeared here voluntarily, so I'll let you sign a $2,000 OR bond.
Okay.
I'm going to order that you appear at the jail for fingerprinting. You have to do that. Mr. Heald, anything on it protection at this point? It looks like this case got a little bit of age on it.
Don't worry, I'll bring you a senator. I'll bring you a copy of it. They were not opposed. I missed the court.
The alleged victim in this matter has called our office and requested that there be no protection order.
Your Honor, if I may, he just advised me he missed a court date on Monday.
That's next.
Okay, all right.
One thing at a time. All right, I'm going to set you back on this matter January 30th at 10 a.m. for a pretrial. You'll need to inform your attorney of that at that time. And then we've got on PRC 25625 A and B, we've got this matter set for review. And it looks like it's alleged on or about 12/15 of 2025, you failed to appear for a sentencing hearing.
Yes, Your Honor.
You admitted or denied that you failed to appear for that hearing.
I'm sorry.
You admit or deny that you failed to appear for that hearing?
I admit.
Okay, you have a good reason for not appearing.
The first one, I was waiting on Genesis to bring a hospice bed in for my mother, and then the rest I was dealing with it. We just put her in the ground Wednesday.
I'm sorry to hear that, and I will accept that as a valid reason. I'm going to set you back for a sentencing hearing as well on January 30th at at 10 a.m. So we'll keep both cases together. We'll need to speak with Mr. Holt about that, and we'll see you back on January 30th at 10 a.m.
All right, thank you, sir.
On both cases. Thank you.
Your Honor, we're ready to call inmates from the jail.
All right. We're going to handle some jail cases next.
State of Ohio versus Casey Burns. Case number CRA 25697, CRB 25698. Casey Burns, back in hold.
Mr. Harrell, you need to mute your microphone.
All right, this is State of Ohio versus Casey Burns, CRA 25697, CRB 25698. It's Mr. Morford's case. Looks like Mr. Burns, you went off to prison. Are you still in prison, or is your sentence?
Yeah, I'm in parole violating the director's orders case, and since he was 2 days over.
Okay. All right. What? Mr. Heald and Mr. Morford, it looks like there's a domestic violence with priors on the CRA 25697 case. It's an F4 and an MM disorderly that we're here on. Mr. Burns is presently incarcerated and in prison, so I don't know if that changes what the state wants to do with this, or
well, there might be a way to resolve it today. What we would offer, we would move to reduce the domestic violence charge to a misdemeanor if he were to plead guilty to that, and offer him a sentence concurrent with what he is serving right now, 10 days in jail, concurrent with what he's serving. And is there a disorderly also?
this MM disorderly.
Okay, so we would just dismiss that.
Okay.
No, can do, Your Honor.
Okay. Well, we're set. We can either, you can give me two options, Mr. Morford, on this. We can, I don't know that it's necessarily set as the preliminary hearing today. Looks like there might have been a little, looks like there was supposed to have been a hearing back on 12/5 was the next hearing, and on it. But looks like intervening when Mr. Burns has been incarcerated, so we can either set this for a preliminary hearing and go down that road, or I don't know what the state's position would be on that, as to whether they're going to want to have a preliminary hearing, allow them to waive or not.
We'll nolly it to the grand jury.
All right. Mr. Morford, any objection?
not really object, Your Honor. I'm not happy it's going that way. I'd rather keep it here. I understand Mr. Hill's wishes.
All right, matter would be Molly Granger.
Yeah. Judge, if I have one second.
You may. Would you want to have it recalled, Mr. Morford, or do you want to?
I think we can resolve it very quickly here, Judge. I won't hold it up. He's had change of heart, and he would take Mr. Hill up on his offer for the misdemeanor and all of the disorderly on.
Okay. And what plea to the domestic violence charge do you want to hear? Is that accurate, Mr. Burns? All right. I'll accept your guilty plea then, and I'll enter guilty finding. It'll be a $100 fine. I'll order you to pay the court costs. 10 days in jail. Concurrent with his sentence that he's currently serving through parole. Is there a request for protection order?
No, Your Honor.
Okay. No request for protection order will be 2 years, level 4 probation. I'm going to set a review hearing in this matter for July 13th of 2026. I'm not sure if you'll be completely released by then, Mr. Burns. If you are, then you'll need to appear. If not, there'll be a warrant and bring it back here immediately after.
His update's 5/14, Your Honor.
Okay. So it'll be 9 a.m. July 13th for review at that time. All right, thank you.
Thank you, Your Honor.
State of Ohio versus Connie Burnside, case number CRA 25358. This is Mr. Stratton's case.
What case is this, Your Honor?
This is State of Ohio versus Connie Burnside. CRA 25358, State of Ohio versus Connie Burnside. Looks like it's alleged that on or about October 6th of 2025, Mr. Burnside failed to appear at his preliminary hearing. I'll give you an opportunity to speak with you.
Yes, Your Honor. Have this recalled, Your Honor.
Yeah, we'll recall this shortly.
State of Ohio versus Chester Burton Jr. Case number CRB 25798, CRB 25799.
Which one? CRB 25798 and CRB 25799. All right, this is State of Ohio versus Chester Burton Jr., CRA 25798, CRB 25799. You may. This is Mr. Steyer's case. We can have Mr. Steyer in the courtroom.
Yes, Your Honor.
Mr. Steyer, this is State of Ohio versus Chester Burton, CRB 25799 and CRA 25798. We were here midweek with Mr. Burton and did his initial appearance. I appointed you at that time.
I
It is-
wasn't aware of that, I'm sorry.
It is an F5 possession of a fentanyl-related compound, and an M1 theft. I gave, at the time, because we didn't have anybody to possibly assess Mr. Burton, I gave him a $2,500 cash assured bond. I indicated that today we would likely revisit the matter of bond, but I did not talk to him about whether he would be interested in treatment or not, which would likely determine what and how much I would be willing to do on the bond.
He's interested in being assessed and
All right.
willing to do follow-up.
All right, Jeremy with RRS can come back and do an assessment on you to see what treatment you would need. And from there, then we'll recall this matter later on the matter of bond.
Thank you. Right there.
State of Ohio versus Lawrence Calderon. Case number CRA 23522 A and B, TRC 19170, TRC 231067 A and B, CRB 1641.
All right, there's the State of Ohio versus Lawrence Calderon, CRA 23522 A and B. We'll start with that one. All right, Mr. Calderon, it's alleged that on or about April 6, 2023, in Fayette Township, you did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance, in violation of Section 292511 AC1A of the Ohio Revised Code. Possession of drugs, that's a felony of the 5th degree. Felonies of the 5th degree carry up to 1 year of incarceration and a $2,500 fine. In the CRA 23522B, it's alleged on or about April 6, 2023, in Fayette Township, that you did knowingly obtain, possess, or use a controlled substance or controlled substance analog. Said drug involved is a fentanyl-related compound or a compound mixture, preparation, or substance containing a fentanyl-related compound, or is a combination of a fentanyl-related compound and any other controlled substance in less than the bulk amount, in violation of Section 292511 AC11A of the Ohio Revised Code. Possession of a fentanyl-related compound, that's a felony of the 5th degree, carries a maximum of up to 1 year incarceration and also a $2,500 fine. Do you have money to hire an attorney? Are you working currently? All right, I'll find you qualified for appointed counsel. I'll appoint Attorney Stratton to represent you. I'm going to, Mr. Hill, matter of bond. We also have a bench warrant issue on a failure to appear from March 18th of 2019. And then it looks like it was reset at some point. It looks like Mr. Calderon may have shown up, and it was set as an arraignment on August 11th of 2023 for the failure to appear, and then he did not appear for that either, it appears. And all of them several old cases. And those are reviews.
Your Honor, we'll ask for a signature on all these matters. There are comments.
Mr. Hill?
Your Honor, taking into consideration the failure to appear on the prior cases and the fact that these cases have been out there since April, don't really know the circumstances that caused it to take so long for it to come before the court, but we would ask that for one of two things, either a $5,000 cash or surety bond, or if Mr. Calderon was interested in talking to somebody about treatment, we would ask the court then to allow him an OR bond if he were to go to treatment, if he needs to go to treatment, and if it's recommended by a counselor.
So, Your Honor, the failure to appear was apparently involved in being frustrated to West Virginia. So he was available to the court.
When was he released from incarceration in West Virginia?
April of this year.
Okay.
So, Your Honor, I think that it'd be okay to get an assessment done, and then follow on the recommendation of that assessment.
All right, here's what I'm gonna do. Just up until we have that assessment done, I'm gonna set bond at $5,000 cash as surety. Does somebody like to assess Mr. Calderon? All right, I saw Jessie back there raise her hand. She's gonna come back and do an assessment on you, and then we will recall the matter after the assessment, and we're going to discuss the bond and where it goes from there. Matter will be recalled later in the docket.
State of Ohio recalls County Burnside, case number CRA 25338.
Mr. Stratton, you may want to keep these two together with their reviews on the same case. All right, we're recalling the State of Ohio versus Connie Burnside, CRA 25358, Mr. Stratton's case.
Your Honor, I have to speak with the prosecutor. I understand the state's willing to reduce the charge on their criminal mischief. Plead guilty to that charge for stating the facts, situation of guilt. And I understand the state will recommend just suspend the time.
Could I have a section of that, please?
Look it up. $2909.07.
And Mr. Burnside, is it your intention to enter a no contest plea that stipulates to a guilty finding for the misdemeanor? Okay. Is that a first degree misdemeanor?
Third degree misdemeanor.
Okay, it's an degree.
And Your Honor, for the record, if I may, this started out as a disrupting public services, but the facts were that, as alleged, that Mr. Burnside took the young lady's phone out of her hand and threw it. There was no accompanying domestic violence charge, which usually those things go hand in hand. There wasn't in this case. They were just, I guess, they were bickering at each other or something. And we have not gotten any information about damage to the phone, so we're not going to ask for restitution.
All right, I'll accept your no contest plea and enter a guilty finding. It's going to be a $100 fine. I'll order you to pay your court costs. How many days has he been incarcerated?
Same way as I know some early these times in here for this, in order, I mean, no excuses definitely on the, this way, but just ready to get this taken care of.
What days has he been at?
Your Honor, he was booked on the 18th.
Okay. All right, so I'll do 10 days jail. I'll suspend 9 and give you credit for the day that you've been in. So it'll be released today. It'll be 2 years level 4 probation. And Mr. Thielman, are you looking for a protection order?
No, Your Honor.
All right. And no contact order is not requested at this time. I'll set you a review hearing for July 13th at 9 a.m. Thank you.
State of Ohio versus Justin Horn, case number CRA 25 203. And this is Mr. Morgan's case.
All right, this is case number CRA 25-203, State of Ohio versus Justin Horn. Mr. Horn is present. It's Mr. Morgan's case. It's set as a preliminary hearing.
Tyler? Tyler?
They can wait to the grand jury, or we can have a preliminary hearing. What's it say now? 15,000?
15,000. It's listed on the charge as 290311 18.
Okay.
Felonious assault.
So there's quite a bit of restitution. If he agrees to stay with the contact and pays restitution and threat not payments, then he's a split charge. Suspended sentence. No contact order. And here's the thing with the restitution. There might be some things that you can, of course, and pictures and estimates and everything here. This is the damage to the car. This is yours. If he's not did that crime victims pay his estimate.
Okay.
And the phone was destroyed. It's not recovered for this incident.
Okay.
Now, there's one more thing, and I told him I didn't know it was wrong. I think this is civil. That when he left the scene, he sped off because it was insensitive. He got a ticket. A speeding ticket. And I said, he's already paid.
He did?
Our victim.
Yeah.
For this incident. He's paid for the ticket, but didn't know if he could compensate for the ticket. And of course, this is for mileage for Canada.
$400 for a speeding ticket.
Yeah, he's got paperwork on it here.
In this court?
Was it here that you got the speeding ticket? Chesapeake. Mayor's Court.
Okay.
But I told him I didn't know about this stuff probably, but if we could come back and he's got a
Okay.
we're not able to just work on it.
Your Honor, we may have a way to work this out today, and I don't know whether the court has time for us to do it right this minute or not, but I think we can make an offer that Mr. Horn might be interested in. This is a serious charge.
I read the narrative. If to be believed, it's very serious.
Yes, and so I can go ahead and just kind of outline it. What it would involve is a plea to a misdemeanor level assault, and this is Mr. Chapman here, and this is your idea, right? There's restitution that is this in addition?
If the court will believe this.
Okay, well, if they'll agree to it, I'm sure.
I mean, but.
All right, so the restitution is going to be around $2,160. And that would include several different things, which I've got this here for them to look at. And it involves damage to the vehicle, it involves medical bills and some other things. The restitution would have to be made in short order. And we would also want a suspended jail sentence of 6 months and probation and credit for time served and suspend the rest of it. But we would want to delay the sentencing, let Mr. Horn out of jail. He'd have to come up with the restitution in a very short matter of time. So we would then agree to the rest of the provisions of the agreement. A no contact order. And it'd be really important for the restitution to be made up front. Otherwise, we would ask to be able to not stay with the agreement for suspended jail. In other words, we would want him to spend some time in jail. What we really want is for this to get resolved in such a way that we don't have to take it to the grand jury. I'm just kind of thinking out loud at this point. I guess I'd like to know from, through his lawyer, whether he thinks he could come up with the approximately $2,160 restitution in short order.
Now, if I'll go ahead and just tell you my thoughts on it. If I'm even going to agree to it, I would want to set a time frame that it has to happen within.
Yes.
And so that, this case isn't, 8 months down the line, we're still trying to come up with restitution.
Matter of fact, I think maybe the best way to handle it would be to give Mr. Horn a bond before there's any plea to anything, and then have him come back with the restitution. Then we would agree to amend it to a misdemeanor, and upon his plea, then we would agree to the remainder of the
We're going to need at least 2 months for the restitution.
Well, I don't know. Is that more time than you want to give him? And Mr. Chapman says that's okay. And I just hope Mr. Horn knows that he's been pretty daggone generous under the circumstances to say that 2 months would be okay. Because I don't think I think that's too long. But we would agree to do that if the court would.
We are meeting with the suggestions.
Okay. So here's what we're going to do then. What bond would you like me to set, Mr. Gill?
I'm sorry.
What bond would you like for me to set in this matter?
Well, it would be, I think, an OR bond, and it should be substantial enough to give it some weight. There's also a protection order in place.
All right. Mr. Horn, I'm going to amend your bond to a $5,000 OR bond. I'm going to keep the protection order in place that's presently in place, which means you can have no contact with Mr. Chapman. You will have I'm going to set you back, and Mr. Morford, I presume you're mindful of the wait time.
Yeah.
I'm going to set you back for February 20th for a preliminary hearing. I'm going to note the time waiver on your client's behalf. Mr. Horn, you better have your restitution at that time. Because I can tell you if the allegations in this are to be believed, you're lucky that you weren't charged with more serious things as well. And that's not to say that if it goes on to the common police court as a felony, that the grand jury won't indict you on other things as well. So I will reluctantly go along with this at this time, but they're giving you 2 months to get the restitution together. If you don't get the restitution together, they're likely going to take it over as a felony at that point. Do you understand? I see you nodding your head, but we're recording. I want to hear you say it on that loud.
And the restitution amount exactly is $2,158.85. That's payable to Tyler Chapman. Let us know if you can. Oh, you didn't have that in?
Well, no, is that 80 cents or $30?
$30.80.
Wait, I need all the couple cents. 17, 20, 80, plus 400 plus $30.80. That's actually, my calculator's not broken. Plus 400 plus $30.80. That's what it's actually coming out.
All right. Actually, we were wrong by a couple pennies. It's $2,159.65.
All right, Mr. Horn, so you're gonna be able to sign your bond and get out today, so we'll see you back on February 20th at 10 a.m. And it would be even if you can't come up with a restitution, to appear for that hearing, because if you show up and they decide to take it on, then you could potentially waive that preliminary hearing and possibly keep your bond. If you don't show up and they nolly the case to the grand jury, you'll get a brand new bond when you get to common police court, and it will not likely be as generous. All right. See you back on February 20th.
Thank you.
Thank you.
State of Ohio versus Donovan Riley, case number CRB 25785 and CRA 25787.
This is State of Ohio versus Donovan Riley, CRB 25785, CRA 25787. This is Mr. Steyer's case and set as on a matter of expedition and pre-trial. I'm sorry.
Your Honor, this matter, we have two matters. We're going to pending theft charge. He's been in jail at this point for about 8 days, and the state is that they're satisfied with that as time served. So we would plead guilty to the theft charge after his 8 days in jail with credit for 8 days served. And then he's got a West Virginia extradition. He's willing to waive extradition. We would ask that he be given a free time without getting.
Okay. All right. And what pleas do you want to enter on the 2575 with that?
Guilty, Your Honor.
I'll accept your guilty plea. Enter a guilty finding on your behalf. It'll be a $100 fine. I will even pay the court costs. 8 days jail, credit 8 days. And 2 years level 4 probation. I'll set a review hearing date for July 13th of 26 at 9 a.m. You get that paid before then, you don't have to show for the review hearing in case of the terminated at that time. And then on the CRA 25787, is it your intention to waive extradition and ask that West Virginia be given a period of time to come and pick you up?
Yes, Your Honor.
All right. Upon that he's knowingly and voluntarily waived his right to extradition with counsel, and I will give West Virginia until the 29th. Yeah, 10 days. With the holiday, I'm going to give them a couple extra days. So I'm going to set you back on 29th.
Your Honor, I'm not available that day, but I'm not sure my presence is all that necessary, honestly.
It would be more of a, did they pick you up, I would be likely to just excuse you from that hearing. You're welcome. So I'll set that as a preliminary hearing.
Also,
Pick that date.
yeah.
They've asked for, it's on a probation violation. I don't know that a bond's been set, but I'll set a 10,000 cash assured bond.
Then
And then,
we would ask that you make that immediately.
Make sure you don't think I'm serious.
Because if he doesn't anticipate most of the bond, that he would tell immediately.
yes, correct.
You have to post it in that level.
And then you would have to either appear in West Virginia to face the charge on your own if you make the bond. If not, then you would need, we'll give them the opportunity to come pick you up. And if they don't pick you up by 12/29, we'll have you back here, and likely you would be released at that time if they don't come get you.
Surety means you can put it through a bond for roughly $1,000. The bond don't usually tend to charge exactly.
Thank you.
Thank you.
State of Ohio versus John Larson. This is for CRA 25777.
All right, this is State of Ohio versus John Dale. State of Ohio versus John Dale Larson, CRA 25777. Mr. Larson is present here today. Mr. Larson, it's alleged that on or about November 1st, 2025, in Perry Township, you did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance, in violation of Section 2925, 11A of the Ohio Revised Code, aggravated possession of drugs, felony of the 5th degree. Felonies of the 5th degree carry a maximum of up to 1 year of incarceration and a $2,500 fine. You have money to hire an attorney?
Yes, sir.
Okay. Are you working currently, Mr. Larson?
Yes, sir.
All right, I'll find that you're indigent and qualified. I'll appoint attorney Roger Smith to represent you. And Mr. Hill on the matter of bond.
Your Honor, I'm just trying to see how this got from November 1st to here, and it took so long to get into court. I guess it happened at a convenience store or something like that. We're not opposed to an OR bond, but if Mr. Larson thinks that he can benefit from treatment, then we'd like to have him do that. If he could get some counseling.
Yeah, I mean, I'm keen to treat.
All right. We'll call this.
I would like a chance to, I'm sorry.
Go ahead, Mr. Larson.
I know some people that's, I mean, obviously very important right now that could benefit from outpatient treatment.
Well, here's what we're going to do. We're going to have you assess and see what it comes back as. Lady in the back raising her hand, she's going to come back and assess you. And then we'll recall this a little bit later in the document. All right, thank you, Mr. Larson. Mr. Smith, do you want to take the file?
Yes. Ohio versus Charles Ritchie. Case number CRV 25766A and B, CRV 25165, CRV 25662. This is Mr. Stratton's case, Your Honor.
All right, this is State of Ohio versus Charles Ritchie, CRV 25766A and B, CRV 25165, CRV 25662. This is Mr. Stratton's case.
Your Honor, we have this on the docket today. Do we have this assessment on it or not?
Well, I thought we had everything done.
Well, we got Mr. Major in the courtroom.
You're probably looking at the new charge. That's, all of this has been taken care of, Your Honor. And this is
Let's see here.
Yes, Your Honor.
The Major, is there a new charge here on Mr. Ritchie?
No, there was a probation violation, Your Honor, for violating no contact order.
Okay, and that's in the 766A case. It looks like, have you seen that, Mr. Stratton?
Your Honor, we had already resolved all this on Monday.
Okay.
So all this is done. We just have to, I believe, release it today.
Yeah, that's my understanding, Your Honor, yes.
So it needs to be released as a
Okay. So is he entering admission to the violation, or is he already admitted?
Sorry.
Okay.
Everything was led to admission, civil entry on the one charge.
I'd just like to say, that he's allowed to go back to his property, he's not, so.
Hang on, Mr. Ritchie, I need you to listen, this is important.
Okay.
I need you to listen.
Yeah. You're allowed to go back to the property, but you're not allowed to have any contact with your neighbors. Okay? So what I would suggest, I can't force you to do this, but I would suggest to have a third party go get your stuff. That way you would not be out there causing problems. But yeah, you being there causing problems with the neighbors is a problem. So if your stepmom would go get your stuff without you, would be best. Okay, you see what I'm saying? That way it takes you out of the equation where you're not getting yourself in trouble. Okay?
All right. I don't know if an entry has actually been done, I didn't see one in the
I
file.
don't see an entry on any of the dockets, Your Honor. I'm not sure I see an entry on 25662 that was scanned that just says, just an entry regarding sexual offender registration and duties and certificate of service the same, but I don't see anything about probation violation.
All right. That's what I saw. How many days has he been?
He's been in what is it?
2 weeks? 6?
Yeah.
Okay.
Yeah.
So he's been in 13 days.
Yeah.
All right, on the probation violation,
And that's 766A.
766A. And I don't know if probation violations were filed in each case, but.
I don't believe so, Your Honor. He's just the one with the no contact order.
Okay. So on 766A on the probation violation, I'll sentence him to 13 days, credit 13 days, and continue him back on probation for his remainder of his original term.
All right, thank you, Your Honor.
Does he have all this?
Thank you. And I'm going to go ahead and, I don't know if he has, did he have a review date originally on this? We're going to keep the original review date on the matter.
Yeah. I think maybe we should have a discussion about him getting this.
Also, Your Honor, he needs to stop by when he gets out of jail next week to work on the sex offender stuff with me.
Your I don't see a review hearing on this case. It's been one documented on entry in the file.
That's what I was trying to look for.
Hey, John, did this happen when he was supposed to be going out there to get his stuff?
Yes.
Okay. So we can talk about that. He still needs to get his stuff.
And that's what I was telling him to have. If you have a third party.
January 12th at 9 a.m.
Okay.
I've already explained that.
Yeah, that's good.
I'm sorry.
January 12th at 9 a.m. is going to be with your review.
State of Ohio, Jeffrey Singer. Case number TRC 242126. TRD 2025-928, A, B, and C.
All right, this is State of Ohio versus Jeffrey Singer. TRC 25-2126, A, B, and C. TRD 20-2599, A, B, and C. TRD 19-2817, TRD 21-752, TRC 21-2872, A, B, C, and D. TRC 2938, A, B, and C. TRD 18-3759, TRD 18-2421, TRD 13-3306. CRA 13-364, TRC 13-1230. TRD 14-3031, TRD 14. TRC 99, 2406, CRB 97, CRB 479, 491. Mr. Morford's case, and Mr. We got a report.
I was actually asked by Judge Capper to screen Mr. Singer for treatment, to which I did, and we were able to accept him. That's what the court wants to do.
Mr. Singer, are you willing to go to treatment?
Yes, sir.
Okay. All right, well, today then, I'll set you an OR bond, a $5,000 OR bond, with only to be released to the counseling center for inpatient treatment.
I'm sorry, which case do you want this put on? I'm not going to pull all of these. I don't even have all of them on my sheet.
We'll do the first one, the most recent, TRC 25-2126.
Do that.
25-2126.
Release to PCC
Correct.
with a, what was it, or
5,000 OR bond. And Mr. Morford, what's your calendar look like in the month of January?
I've got a couple of jury trials ready to do the month, Judge. You have a picture of the
January 16th?
I'm free.
All right, so we're going to set Mr. Singer for January 16th to give him time at 10 a.m. Give him time to get into treatment and get situated. Now, Mr. Singer, you see the amount of files that you have here. And, you know, I'll be honest, it's gotten to the point that it's pretty unwieldy to read them all. So my anticipation would be if we decide to leave treatment and not do it, there's a whole lot of time here that I can impose one after another on these cases. And I don't really want to do it, but we're getting to a point where there's not a lot of choice. Okay? So as long as you do your treatment, that's not going to happen. But if you leave, that may very well be what I'm forced to do. Okay? All right, see you back January 16th.
Thank you, Judge.
That's good.
State of Ohio versus Lawrence Calderon. Case number CRA 23522A and B, CRC 19170.
The state of Ohio versus Lawrence Calderon, CRA 23522A and B, CRC 19170, CRC 23167, CRC 16411. Mr. Stratton's case, we're calling it on the matter of bond after a treatment evaluation.
I spoke with Lawrence, and we were able to approve him for residential treatment. We could pick him up today.
All right, Mr. Calderon, is that something that you're interested in?
Yes.
All right. Mr. Hill, I believe you had already indicated you were okay with.
We are, Your Honor, and even though this is a felony charge, 2 of them, we want him to be successful in treatment. Now, I don't have the benefit of seeing Mr. Calderon's criminal history at this time, but I'm presuming at this point that we're going to want to keep the case here and have him be successful in treatment. And if he does that, these charges could go away completely, unless there's something lurking back there that makes me have to change my mind, but I'm not presuming that at this point. So we want him to go to treatment. We're okay with an OR bond, and hope he stays put there and gets some help.
All right, I'll amend bond to 5,000 OR, and then we release the hometown for inpatient residential treatment. All right, Mr. Stratton, when do you want to come back? January do you want to, if he's going into treatment, or are you going to wait time on the preliminary hearing?
We'll wait.
All right, let's set this for, are you available January 16th? Preliminary hearing of your trial.
Thank you, Your Honor.
Thank you.
Oh, it is it? Okay, I'm sorry.
State of Ohio versus Jesse Lee Friend, no recall, hold, case number CRA 25355.
All right, this is State of Ohio versus Jesse Flynn, CRA 25355. This is Mr. Smith's case. And it says, looks like Coleman, 2000.
Jesse's got the case pretty firm, this round will come up. Unfortunately, I don't have to top of my head what the date is. Did you get that condition letter from Mason County, West Virginia? You thought it went away, it popped back up. It's been hard to get around. Since October.
Yeah, Well, it looks like there was an order back in June, defendant to turn himself into Mason County by 6/20/25 at, it's like 8 PM or 8 AM, if not appear in this court on 6/20 at 10 AM.
He was re-engine, correct? In Bethesda. And Bethesda was trying to help us figure out what the Mason County wants immediately, let our case be resolved, they put a hold on him, take him back there once we're done, but he has several pending charges, one just valor, and or the official state. They're still interested in bringing the state and find out Mason County, they still want him. Just put a hold on him, let us finish our cases.
We can certainly try to find out.
When's he due back for Judge Fowler? We set it the 16th, would that be?
I will not be here the 16th, so it's either the 7th or 21st.
Why don't we do the 23rd, if you available then?
I should be judged. I am, that's a Friday, I've got something this morning, yes.
January 23rd, 10 AM.
Between the state and myself, we'll figure out what Mason County's position is changed.
Okay. That'll, and hopefully maybe that'll, the common pleas matter will be wrapped up and we'll wrap it up then.
That's mine.
Or at least have some ideas of where it's headed.
You've got a call for the process, so yeah, I think we can.
All right, January 23rd, 10 AM.
State of Ohio versus Jarrett Sipple, case number CRB 25-545, CRB 25-468, A and B. Your Honor, Mr. Ashworth is special prosecutor in this case.
All right, this is State of Ohio versus Jarrett Sipple, CRB 25-545, CRB 25-468, A and B. Mr. Sipple is present, attorney Mr. Smith. And we got Mr. Ashworth present via Zoom. Mr. Ashworth, can you hear me?
Yeah, John, thank you.
All right.
We had a special prosecutor on your case.
Mr. Ashworth, I don't know if you've had an opportunity to speak with Mr. Smith, but I'll start with you on where we're at on this.
This file was transferred about a month ago.
Yeah.
I have a proposition for Mr. Smith, but I haven't talked to him. So I asked that we just reset this for a pre-trial, actually, if that's okay, Roger.
Oh, absolutely, Judge. I wasn't aware that the state had got a special prosecutor. Absolutely, I'll call Mr. Ashworth. If we could reset this just after the first year, I want to speak with him and then try to figure it out.
Mr. Ashworth, what's your calendar look like for January 23rd? I know Mr. Smith's already here that day, but...
January 23rd, Your Honor?
I'm here then.
I'm there, actually there for a trial, so...
Okay, perfect. I'll set it then for January 23rd at 10 a.m. And that way you guys will have plenty of time to speak. And you're already here, Mr. Ashworth. We may be able to wrap it up at that time.
Your Honor,
Yes, sir.
what are the case numbers on that?
On this one?
Yes.
CRB 25-545 and CRB 25-468.
I got a special prosecutor.
Thank you.
Okay.
Thank you, sir. I'm here,
I'll call you, Ryan.
No, it was, Mr. Hill had asked the question and it wasn't really pertinent as far as what we were doing on this. So that'll be the court's order. I'll see the court back on January 23rd.
Thank you, Judge.
Yes, sir.
I'll call you, Ryan.
Thank you.
Yep.
Sounds good. Merry Christmas.
Merry Christmas.
State of Ohio versus Nicholas Atkins, case number CRB 24293, CRA 24294, CRB 24295.
All right, this is State of Ohio versus Nicholas Atkins, CRB 24293, CRA 24294, and CRB 24295. Mr. Atkins is here with this attorney, Mr. Smith.
That didn't happen the way that
said it happened. And I went to the program leader that was present when it happened, had him to write out what happened, and I have a picture of that.
Was this the counseling center?
No. This is just a sober living in Huntington. And to try to appeal to him, to get him to let me back in. And,
Okay.
At that point, they said the damage is done, we just move on.
Well, Judge, he graduated, I guess, the program at TCC. He was in a sober living residence recently. OVP, I'm sorry. He was at TCC one time. But, Judge, this case has been going on forever today. I don't know if the state wants to terminate it today or what else we're going to do, but it's been pending since sometime in 2024.
Well, the last time we were here, I believe.
May 14th of 24, almost 2 years.
We were here on October the 14th this year, and we were told that he's at a facility in West Virginia. I don't have any more details than that. And he had 5 more months to complete that program.
So I'll just tell you guys what I just told him. I had graduated from OVP, and I was in a sober living in Huntington. And there was an incident with a neighbor, and I got discharged from the sober living. And it didn't happen the way that the neighbor said it happened, so I went to the program leader that was present when the incident happened, had him to write a letter to the director for me to try to get him to let me back in. The director wouldn't hear me out. I reached out to a board member on Facebook. He called me, and then at that point he said, well, the damage is just done, just move on, I wish you the best. That's what happened.
I guess my position would be, Judge, he graduated OVP. This is almost a 2-year-old case. I don't know. Getting kicked out of sober living, I don't think that's a requirement of the program because he graduated. If he just checks himself into sober living, it's unfortunate, but I don't think that we really should go any further after 19 months of monitoring, Mr. Hack.
Because the OVC program is a 30-day residential program, it is their custom to direct somebody into outpatient services after they complete the OVP residential program, and that's what I believe happened here, that he was supposed to go and receive the outpatient services. So I don't know, it doesn't sound like it's happened. The main thing is that we want to make sure that Mr. Adkins is, even though this has been going on since 2014, he had possession of fentanyl. We don't want to find out that he's dropped dead somewhere. So I think it would be probably valuable knowledge to see if he, if he took a drug screen today, if he's having problems.
I'm good.
I was just thinking that.
We called him drug, sure.
Have him screened.
I'll call you back.
We'll recall this a little bit later in the docket when we have that information.
Thank you, Judge.
Thank you.
State of Ohio versus Earl Carter, case number TRC 25-1974, A and B. Earl Carter.
The State of Ohio versus Earl Carter, TRC 25-1974, A and B. Earl Carter. This is Mr. Smith's case. Mr. Smith is present, however, his client is not here.
Judge, I would ask that, I assume the court will issue a bench warrant, because I've had no contact with him why he wouldn't be here. If it could be held for 7 days, I will attempt to find out why he has not appeared this morning.
All right, there'll be a bench warrant issue in 7 days to appear.
Your Honor, I would ask that the court take a look at the drug screen that came back and maybe reconsider when the warrant should be issued. This is concerning.
I don't know that I have.
Could you try to pick it up to him?
Drug screen.
Does he have a bond up?
I don't know.
With Gary?
No more bond.
Oh, okay.
Yeah, I agree with the state. We're going to issue the warrant immediately.
I'll still try to get hold of him, Judge, and get ahead of the curve if I could.
Absolutely.
State of Ohio versus Jason Harrell, Case number CRA 25-427, CRB 25-428, A and D, CRB 25-429, A, B, and C. Mr. Carroll is on Zoom, Your Honor.
The State of Ohio versus Jason Harrell, CRA 25-427, CRB 25-428, A and B, CRB 25-429, A and B. Mr. Harrell's available via Zoom today. This is Attorney Roger Smith is here in court.
Yeah, now that we've got him to stay put, he's doing great.
That's the first part of it.
Yeah.
That's good.
Yeah.
It's a good report, Mr. Harrell.
Thank you, Your Honor.
You're not ready to graduate, so you just need to come back down. Yeah, I'm assuming.
If I may,
You may.
he has been terminated from QRT.
Okay. Mr. Smith, when you will come back.
Judge, let's see. I am here. Do you want to go a couple weeks or a month? How far out would you like to go?
You come back 23rd since you're already here.
Yeah, I'm here that day. If that's, yeah, we'll do that.
January.
Okay, January.
All right. Defense request matter will be set back January 23rd for pretrial and preliminary hearing.
Thank you, Judge.
Thank you, Your Honor. Thank you, Mr. Harrell.
State of Ohio versus Candy Long. Case number TRC 25-2939.
The State of Ohio versus Kennedy Long, TRC 25-2939. Ms. Long is present here today with her attorney, Mr. Smith. Matter set as a pretrial.
Oh, good. Judge, I've been handed a letter by my client. Just that you can, Judge, have this.
Yes.
I could approach on, she said you can have it. It's an original. I'll show Mr. Hill.
I did, Judge Roger. I will call her.
That's
January 5th.
This is yours, Jane. I will call her.
Hey, Roger. Where is she at treatment?
Yes.
You have an appointment next week?
Yes, I do. On the 10th.
On
Thanks Friday, this Friday
oh,
coming.
Friday the 29th?
Yes.
What date that is? 26th? The day after Christmas, are they open?
Yeah.
Apparently she has an appointment the day after Christmas, Judge, at OVP.
I've got my appointment card out there in the vehicle.
I could do in January, of course, the 23rd date, the 5th.
Can it be on Fridays?
She'd like it on a Friday if possible, Judge, so maybe we use that 23rd date.
Choose the 23rd.
We'll get a report hopefully from OVP by that time.
Can I
All
get
right, defendant's request is not to be continued on January 23rd for pretrial and preliminary.
Well, that's
Where's this name for you?
State of Ohio versus Chester Burton on the recalls. I can hold it. Case number CRA 25-798, CRB 25-799.
That's your next.
This is State of Ohio versus Chester Burton Jr., CRA 25-798, CRB 25-799. This is Mr. Steyer's case. We've had Mr. Burton assessed by RRS.
Qualifies for treatment, OVP is where he would need to go to first, just for the simple fact what drug he's coming off of. I've talked to OVP, they do have the bed open. They're going to call the jail when he gets back down there for assessment.
So, we're gonna have to be assessed, I would, couple ways we could do this. One would be to go ahead and set the, I know our law released the OPT and set this this back for Monday, so we see what's happening. And if you're going into a detox, you may not be able to be here Monday evening with OPC. Or we could just set it again for Monday, because he's detoxing right now, we can get into bed today. It's probably a better option.
Mr. Hill?
We're agreeable with that.
All right, Mr. Burton, I'm going to set your bond at a 5,000 OR bond with an order that you be released only to OVP for treatment. I'm going to set you back for December 22nd for preliminary hearing and pretrial. However, with the understanding that if you're released and you're an OVP, that you won't need to appear for that.
Thank you, Your Honor.
All right, thank you. Mr. Burton, go do your treatment. Things will go much better for you if you do. That was kind of my intention all along, was to make sure you got assessed and that's got sure you believe. And you're very welcome.
State of Ohio recalls Nicholas Atkins, case number CRB 24293, CRA 24294, CRB 24295.
When we come back on Chester?
Monday, so we're within time.
Okay. That was great.
All right, this is State of Ohio versus Nicholas Atkins, CRB 24293, CRA 24294, and CRB 24295. We recalled the matter on drug screen. Mr. Smith, Mr. Hill, have you seen the results?
Judge, I have not, but my client indicates it would be positive for THC, and I don't assume any other drugs.
There was buprenorphine, which by presuming should be in the system.
Yes. But I think fentanyl was the big concern, and that should not be on there.
All right.
What I'd like to do, Judge, is come back one more time. I'll get with OVP and see if this sober living is mandatory, because I'm a little bit I guess confused as the word is exactly what's going on with this new revelation about the
Well, what happened with the program, I didn't have really many options because I had West Virginia insurance, so I only had sober livings that would take me over in West Virginia after OVP, so that was the issue with
All right, I'll set it back on the 23rd.
And I'll get with OVP and get a little more clarity next time we're here.
All right, 23rd at 10 a.m.
Remember?
Or actually, Mr. Smith, are you here the 30th?
I think that's the date I have the Jesse Friend trial. Let me double check. It seems like the end of the month I have. Yeah, that's the day Jesse Friend is set for the 29th and 30th.
Okay.
As of now, we have a final offer come up. I hope to resolve it, but as of now, I'm not sure that would be a good one. I'm here to...
Let's leave it on the 23rd.
Okay.
All right, January 23rd.
123 at 10.
Yes, at 10 a.m.
Good Christmas. See you then.
Well, I was here the 30th, so...
Yeah, well, I'd probably want to get that worked out, but as of now, it's still showing it.
Here, Roger.
State of Ohio versus Bobby Adams, case number CRB 25615.
This is State of Ohio versus Bobby Adams, CRB 25615. Ms. Adams here for attorney Mr. Stratton. Matter set for pretrial.
Your Honor, the state has offered to plead to this. The state has offered to plead to this count and offered suspended time. At this time, we'll just ask that it be set for a trial.
Sorry.
Set for a trial. Yeah.
Mr. Hill, when would you want that to be set? Or how much time do you need? set it for the 30th
Of this month?
of January.
Oh, that'll work.
Mr. Beal?
The rest of this year is
It's okay
crazy.
with us.
All right. I'll set this for January the 30th. For trial at noon. And I'll be here that day again.
State of Ohio versus Portia Anderson, case number TRC 252585, CRA 25642, TRD 252573, A and B.
All right, this is State of Ohio versus Portia Anderson, TRC 252585, CR 25642, TRD 252573, A and B. This is Mr. Stratton's case, and Portia Anderson.
Your Honor, Ms. Anderson's not going to be here today. She had an emergency in South Carolina. Also on this case, the results of the OBI are not available yet. So I think the state is in agreement that we can just continue this and set it for another date.
Is that correct?
I'm sorry, I was trying to work on the last case. What was the?
Portia Anderson, this is the one where we don't have results and she had the emergency in South Carolina.
We don't have the results.
And you're okay with continuing it?
Under the circumstances, yes.
How far out do you want to go, Mr. Field? It looks like this was October 20th was the first pretrial. We're on 10/10.
Whenever the state thinks they can get results, I guess.
Well, and I think the fact that she's not appeared would toll the time until the next hearing.
Oh, yeah, we'll waive time.
Yeah, okay. So it would be at the defendant's request anyway, so. Okay, I'll find the time to be waived on behalf of Ms. Anderson. And when do you want to set that, Mr. Hill?
It's up to the court, Your Honor.
I didn't know if there was a specific time frame that you were looking at.
Well, the time would be running approximately January the 7th, but...
With the tolling provisions, it would not, because he's going time now, so.
Yes, so we're okay to go beyond that.
All right, Mr. Stratton, you're already here on the 30th, let's set it for the 30th.
Yeah, 30th is fine.
All right, we'll try on preliminary hearing.
State of Ohio versus Micah Calico, case number CRB 25602.
All right, this is State of Ohio versus Michael Calico, CRB 25602.
So you're still in your
Stratton's
Yes.
case set for
Is
pretrial.
there anybody here?
Yeah, he's right there, director. The one.
She's in the anger project in Montgomery.
It would say Albans.
St. Albans, St. Albans, sorry.
Yeah, you're good. That was the prayer.
That was Primal, I'm sorry. And I believe the state just needed confirmation that she did that.
I'm still working on the last case.
Okay.
Oh, yeah, she's been doing treatment somewhere and such. That's why I'm not. Since October 15th.
She's the what? Case manager?
Your Honor, the last time we were here in court, we wanted to make sure that she was in a treatment program. And apparently she is. What's the name of the program?
Anchor Project,
And that's in where, St. Albans?
St. Albans.
Is your mother here?
No.
All right. Understanding also that she has some court involvement in Putnam County as well.
Yes.
So I think under the circumstances, Your Honor, it would be appropriate for us to go ahead and nolly this charge.
All right.
Dismiss.
There was no objection.
No objection.
All right, at state's request, this matter is going to be nolly.
All right.
Thank you so much, Your Honor.
Thank you.
Thank you.
State of Ohio versus Marion J. Holland, case number CRA 25724, CRA 25720.
All right, this is State of Ohio versus Marion J. Holland, CRB 25.
How you doing?
724,
I'm not too good.
25,
Yeah,
720.
I heard. Can we try to get this dismissed today? Crunch on this?
Yeah, we'll crunch it. Give me a chance to stand up.
So try it. Do the 30th, you're already here on one. All right, after a brief pre-trial conference at the bench, we're going to schedule this matter for January 30th, and it's going to be a trial at noon on all cases.
Yes.
Okay, I see you the 3rd. Thank you. All right. Have a good one.
State of Ohio versus Dustin Hines, case number TRD 251837. Dustin Hines.
The State of Ohio versus Dustin Hines, TRD 251837. Dustin Hines. Mr. Hines is not here today, however, his attorney, Sean Stratton, is present. Stratton, the idea of your client is.
No, Your Honor. I have 7 days before a warrant's issued.
Be a bench warrant to issue in 7 days.
State of Ohio recalls John Larson, Latin Holding, case number CRA 25777.
This is State of Ohio versus John Larson, CRA 25777.
Yes, he did assessment treatment, so we'll ask for no
What agency are you with?
Focus, I'm filling in for that, please.
All right, Mr. Larson is now present in the courtroom. His attorney, Mr. Smith, who had previously assessed for treatment in the matter. Mr. Larson, it looks like he's qualified for residential treatment. My intentions would be, if you're willing to do that, would be to give you no R bond today and let you be released from focus for treatment. All right. I'll give you a $2,000 OR. Release focus for treatment. Residential treatment. Focus. And Mr. Smith, when would you like to come back? I would say the 23rd is probably getting a little
It is,
busy.
you want to come back maybe on the 8th just to make sure he's doing well in treatment.
And not- Okay. 5th, pretty busy.
You just to get a hand in and see if the mother is hospital.
Sure.
We'll just get started maybe.
On the 9th.
The 9th I'm not here.
Okay. How about the 12th?
I'm on that. Well, I could do, if I could ask a favor, get called out first, I've got to be somewhere at 11 on the 9th. I can get in, kind of called out of order, as long as it's in, I can do the 9th.
All right, I'm gonna set you back January 9th at, well, I'm gonna put 9 in here, even though that's not the typical thing, Mr. Larson, that way. On the entries, that way focus will bring you up early, that way Mr. Smith can get a call.
Yes. Focus is they can be here at 9 o'clock on that day, so that works.
All right. Mr. Larson, will you release today to focus when they come get you? Well, and hopefully that will help your case.
Today, is Devin Miller. Case number CRB 25-422, A and B. Devin Miller.
So the state of Ohio, this is Devin Willard, CRB 25-422, A and B, it's Mr. Steyer's case. Devin Willard.
Your Honor, we had previously come to an agreement on this matter on a prior occasion. Mr. Willard lives in Columbus and has had difficulty getting down here. We, I think, agreed to a disposition that we were going to present to the court on video last time we had the case, and reset it to today. This morning, Mr. Willard contacted me, said he couldn't get down here.
Mr. Hill?
Yes. And everything that Mr. Steyer said about our previous agreements is true. I anticipated he would be here today and we would get the case resolved, but this has happened, I don't know how many times, but more than twice, I think. So we'd ask for a bench warrant.
All right, Mr. Steyer, any comment on that?
Your Honor, I will advise him that if he can get down here before 7 days, that he would beat the bench warrant, but that's about all I can say at this point, Your Honor.
All right, I'll notice failure to appear, there'll be a bench warrant issue in 7 days.
State of Ohio versus John Heisel. Case number CRB 25-608.
Yeah, that might list Mr. Steyer, but that is my case right.
All right, this is State of Ohio versus John Heisel, CRB 25-608. Mr. Heisel's present, his attorney, Sean Stratton. Matter set as a pretrial.
Your Honor, we could just set this on the 30th for a trial also.
Tiffany Chapman.
Well, I don't want to put 3 trials on the 30th.
Okay, we'll pick a different day.
Good, honey.
Are you available the 23rd?
Yes.
Oh, all right.
Oh, what, 23rd good? Yeah. Okay.
For a trial at noon. Mr. Hill, does that give you enough time?
I believe it does. Our star witness is here. I know she'll be here on the 23rd.
All right. I'll see the parties back January 23rd, noon for trial.
All right, here. You're good. You got another one?
And on that day, you'll tell what happened. Thank you. All right.
State of Ohio versus Emily Justice. Case number CRB 25-529.
Of here.
All right, this is State of Ohio versus Emily Justice, CRB 25-529.
There is a co-defendant, but I'm not certain who represents her, also with the last name Justice.
Emily Justice.
State of Ohio versus Crystal Justice. Case number CRB 25-528. Morford's case.
Morford, okay.
Crystal Justice.
I'm Crystal, Emily's
All right. And we got State of Ohio versus Crystal Justice, CRB 25-528, Mr. Morford's case. Sure, 7 to 3 trial.
Okay. Your Honor, this matter is one where the allegations involve damage to a vehicle. My understanding is that at some point, we're gonna, we are anticipating getting a restitution figure, which that figure is gonna be part of our discussion. We decided we want to try to resolve the case short of a trial, and as of this morning, they don't have the restitution figure. So I would assume the state's gonna ask for a continuance once more to try to get that restitution figure, and eventually, I guess if we don't get it, we'll probably just have to either, they'll have to make a decision not to seek restitution, or that we can, or we go figure something else out. But right now, we don't have enough information to settle the case.
We're also looking for video from the neighbor and body cam video.
Yes, to all of that, understandable. And at this time, we do not have a restitution figure, and we haven't obtained the video from the neighbor. Under the circumstances, I think that the best we can do at this point is to nollie the charges, and with the understanding that we might refile them when this information becomes available.
All right, I assume there's no objection.
No objection on my behalf.
No objection.
At state's request, they'll be nollied, and that'll be without prejudice.
Not come in with quickly?
Take all it again.
Thank you. Thank you.
State of Ohio versus Rush Runyon, case number CRB 25746.
This is State of Ohio versus Rush Runyon, CRB 25726. Mr. Runyon is present with his attorney, Mr. Warren. The matter is set as a pretrial.
They should have without, if she was here. She ain't here, they should have without.
Linda Thacker.
She ain't here, they should have without, shouldn't they?
Well, they can get a continuance for one.
And that phone number is actually her cousin's phone number. And I left a message for her cousin to have her call because she uses her cousin's phone and she won't have it.
Did we issue, okay, so Your Honor, we asked for a subpoena to be issued for Linda Thacker, and I don't know if there's anything that's filed to verify that she was served or not served.
There is a note in the court file, 12/12/25 subpoena not served back on 12/9, vacant, returned by Deputy Hamlin as vacant.
Okay.
Vacant, oh, property vacant?
Property or vacant.
All right.
There's a subpoena in the file for more information.
There's a subpoena, but it doesn't appear that there was any other, that was the only subpoena that was in the file.
Will Nolly with the right to refile later if she comes forth.
All right. State request, this matter will be Nolly with the right to refile.
It's dismissed. Yes, sir.
Thank you, Joe.
Thank you, Judge.
Thank you.
State of Ohio versus 6 Bentley, case number CRA 25359, CRB 25360.
She's on Zoom, I believe, Judge.
This is State of Ohio versus 6 Bentley, CRA 25359, CRB 25360. Ms. Bentley is presently a Zoom. Bentley, can you hear me? Ms. Bentley, can you hear me?
Yeah, I can hear you, sir.
Okay. And her attorney, Mr. Smith, is here in the court. All right, good report.
She's doing well.
We Judge, she's still treated, I have the 26th of January available, so I don't crowd.
Why don't we go out to early February?
That's even better. I have more availability then. I'm here the 9th, 13th, 16th.
Even 9. That'll be a preliminary hearing.
We don't know.
What's the date, John?
February 9th.
State of Ohio versus Autumn Clark.
Yeah.
Case number TRC 25707 A, B, and C, CRA 2515.
All right, this is State of Ohio versus Autumn Clark, PRC 25707 A, B, and C. Ms. Clark is present with her attorney, Mr. Smith. Matter set at the pre-trial. Preliminary hearing.
Your Honor, I would also like to note that she has $100 to pay on her outstanding balance to the court. And she will pay that today, correct? Yes.
I was going to say, I don't know that I have that set for the day, but
She just mentioned she had it, and it's Christmas time, so I thought it'd be better for the court to go ahead and get it. And she's going to pay it.
I'll maybe in the same folder,
well,
we may need to have that full.
no, it's here. Yeah, it's in here. It's in there. Yeah, it is in there. I just, I didn't see that that was the CRA case. Still pending. It appears she's completed her treatment.
She has, Judge, and I was just checking with Mr. Hill how he wants to proceed as far as finishing the case there or coming back.
We're not opposed to doing that. The OBI case, 25 TRC 707, I don't think it's been sentenced.
It has.
Okay. Well, if everything's been sentenced or disposed of in one way or another,
I think the only thing,
maybe the endangering?
I think it's the possession and the endangerment. And I think drug abuse instruments.
All right. We will move to nolly those charges.
All right, at state's request, all the remaining charges are nolly.
I appreciate the state doing that, Judge, and she will make that payment before she leaves.
Ms. Clark, you've done very, very well, and the fact that you've done so well got you all of those charges dismissed. All right.
Thank
very
you.
much.
What was, sorry, the review date on the OBI?
Let me see.
Do you want me to catch her? She's going to the window
Yeah,
for the
you
day.
may.
Can you grab her and have her come back? Yeah. We got something, thanks.
Oh, she's in the back.
Oh, okay, just whenever she gets out, just have her, thank you. She's in the restroom, Judge.
There's not one set on it at this point, so we'll set it for, we'll do the regular review date from where things were before. She's making some here, instead of setting, she's done well, so I'll set her for July 13th of 26 at 9 a.m. for.
I'll make sure she has.
She doesn't have much left on the case, so she'll likely have it wrapped up.
Did you say July 13th, Judge?
Yes.
9 o'clock, okay.
State of Ohio versus Tara Curry, case number CRA 25332. Tara Curry.
This is State of Ohio versus Tara Curd, CRA 25332. Ms. Curd is present with her attorney, Mr. Smith, for setting the preliminary hearing.
May I approach your honor?
You may.
We got a script.
She recently took a pass and tested positive for methamphetamines, which made her non-compliant. She did admit to it, and we are currently doing a 90-day refocus. She's done extremely well up until this point.
Yeah, she had, up to this point, Judge, I was encouraged by her progress, but I was not quite there yet. Whatever date the state, Your Honor, will come back, we will find a date we can do that.
How about Mr. Smith, did you say you're not here on the January 26th?
I am here the 26th.
Let's do the January 26th.
Yeah, I was trying to do that as an alternate date to the 23rd, which is
January 26th.
26th. Yes, I am here then, Judge.
For a preliminary hearing at 10 a.m.
Thank you, Your Honor.
Now, Ms. Curd, we've been encouraged by your progress so far. This is a step back.
Yeah.
But I'm encouraged that you didn't deny it, you admitted it, and you've taken accountability for what happened. And because of that, I'm going to give you more opportunity to continue with your treatment and do well.
Okay.
So let this be a step back and not a step out. Okay?
Thank you.
All right, see you back January 26th.
Thank you, Your Honor.
Thank you.
State of Ohio versus Adam Leonard, case number CRA 25195, CRC 25619, CRA 25383.
This is State of Ohio. May I approach? You may. CRA 25195, TRC 25619, A and B, CRB 254.
Was this a first offense? Or something? Did you, was it charge? Was it this year? Why would you take it when FBI wasn't?
No, that's not, the license was expired. And now they're suspended.
Good report, Mr. Leonard.
Thank you.
And, Your Honor, this is a case that I inherited from my brother. Apparently, there's a license suspension. It's not an OVI case, but they were expired. Now they're suspended. I'd like to look into that matter, and if appropriate, move for driving privileges, but I don't, at this point, know right now exactly what's happening. As soon as the state won't oppose that if...
It was an OVI.
Was it? OVI?
There's an OVI in this.
I thought you said it wasn't OVI. Well, then, at the time...
Yeah, it's TRC
It's the last week.
25619, A and B, and that was resolved back in June. On June 13th. And
Do you, and like I said, I inherited this case. Was he suspended that day?
I'm totally looking at.
Okay, because he could...
You're on this on the computer and you can't find your answer.
It was a refusal on March the 31st. So that's when the 6 months suspension would have started, so it should be over by now. So he could reinstate.
And to get the license, you gotta file with BMV and the reinstatement fee. You're not, this court suspension.
Yeah, it ended 9/27/25.
Okay.
When the suspension
It will
was
stay in
up.
effect until you get with the BMV and say, hey, I need to pay my reinstatement fee. Didn't know reinstate.
Okay.
Why don't we come back January 26th?
Yes, Judge.
That'll be a preliminary hearing at that time. So, in order to reinstate, you'll have to go deal with B&B for that. You should be able to go to B&B and reinstate your license at that point now.
Okay.
The suspension's up. Now, I don't know if you owe, if there's another suspension somewhere else, but as far as from the OBI that you were suspended out of this court, that suspension is now over. So unless there's, I don't have it in front of me, I don't know if there's maybe an unpaid ticket somewhere or anything like that that would hold you up, but assuming that the only suspension is from this court, you should be able to go to B&B and get your license back.
Okay.
Okay?
All right.
Thank you, Your Honor.
Thank you, Judge. Roger, yeah, appreciate it, sir.
Thanks.
State of Ohio versus Raymond Jenkins, case number CRN 25786.
The State of Ohio versus Raymond Jenkins, CRA 25786. Mr. Jenkins' presence was attorney Mr. Roger Smith. Matter says preliminary hearing.
Yeah.
Your Honor, Amanda Saunders is here. She's the alleged victim in this matter. And she is urging me to understand that the situation was mutual between them, and that even though she ended up with a bloody lip, that it was her own doing, and that she was being aggressive towards him too. So, under the circumstances, I'm going to choose to believe at least that, she's trying to tell the truth here, and that she doesn't want this pursued. We're not willing to dismiss the charges today, but if Mr. Jenkins would agree to wait 90 days for a dismissal and not have any problems, and then we get it dismissed in 90 days with the payment of court costs, we'd be agreeable to doing that.
Judge, that's fine, we'll do that. We just need to, I guess, pick a 90-day benchmark.
March 20th.
That'll work, Judge. That's far enough out, that will work. And if there are no further problems and he pays the cost on it before that date, would he have to appear?
I'll tell him.
Your Honor, there is a TPO currently issued, does that mean withdrawn?
She no longer wishes to have protection.
We'll withdraw the protection order at person's request. All right, we set for March 20th. working fix for preliminary hearing, making sure the problem will be dismissed on payment costs. With this being a felony, Mr. Smith, I'm going to order the appearance to be made.
Okay.
Just in case that there are problems that are brought up that,
Sure.
rightly or wrongly, if something does get brought up, I want Mr. Jenkins here. But assuming that there are no problems, it will be dismissed that day on payment.
Could I make sure how much the costs are? I get every court confused.
It's typically 125, but it looks like there was a subpoena issue, so there may be. $160 would be the cost.
$160? March 20 for $160. Yeah. Yeah. All right, take care, man. See you.
Okay, so I'm going to dismiss that.
State of Ohio versus Michael McComas, case number CRA 25579.
All right, this is case number CR 25579, State of Ohio versus Michael Thomas. Mr. Thomas is present with his attorney, Mr. Smith. Set for preliminary hearing.
That's great. Okay, I gotta recall this.
Best report of the day so far.
Yeah, I'm just getting through it, but it's so far, it's really good. Judge, given the fact he's doing so well, he's been in since September, we could maybe use that February 9th date, kick it out a little longer.
Well, in a prior hearing, we had discussed having the case dismissed to QRT. And apparently, he's done very well this time. And if Megan's still here, I wanted to have that discussion if you may.
Basically what that
Yes, she's here.
Leave
So this is Michael Thomas, and we talked about dismissing to QRT. So we're willing to do that today, Your Honor.
Even better, Judge. He's going to do QRT, and I explained to him, I'm sure Megan is, he has to complete this treatment.
He's compliant, doing well.
All right. You know, QRT.
Thank you.
Stay in touch with Megan. Okay. Thanks, yeah, just complete your treatment, you're good.
State of Ohio versus Angela Ray, case number CRA 25649.
This is State of Ohio versus Angela Ray, CRA 25649. Mr. Ray is present with the attorney, Mr. Smith. Set for preliminary hearing.
Looks good, Judge. I don't know how far out we want to go.
I've been informed, Your Honor, that this is another candidate for a dismissal to QRT. So we're willing to do that today.
She's indicated she's in agreement with that, and Megan, is that good?
Yes,
Good.
she is compliant, doing well.
Based upon that, it will be known to QRT.
Thank you, Judge.
Thank you, Your Honor.
State of Ohio versus Aaron Honey, case number CRA 25279.
This is State of Ohio versus Aaron Runyon, CRA 25271. Mr. Runyon is present here today with his attorney, Mr. Stratton. Thank you all.
They got a couple issues. Things are getting better, right?
I've got to note that if there's not a good report, this has got to go to the grand jury. Maybridge.
Hey, Sean.
They just took me down there.
No.
Sorry. I thought I was taking me down there.
All right. That's a much better report, Mr. Runyon, than the prior ones.
Sir.
John, we continue on.
When you want to come back?
We could look this up at the end of January.
About February 6th.
Just a second. Sheets. February 6th is good. February 6th.
Thank you, Doug.
All right, February 6th for preliminary hearing, 10 a.m.
State of Ohio versus Municipal, case number CRA 25153, CRB 25144.
This is State of Ohio versus Craig Wysong, CRA 25133, CRB 25144. Mr. Stratton, this case.
How's he doing?
Set the preliminary hearing.
It's a good report, Your Honor. You know, is an outpatient.
Yes, sir.
And working full-time, right?
Very good, very good.
We use that February 6th date if the state is okay with it, Your Honor.
Say it again?
We can continue on and use that February 6th date.
February 6th, 10 a.m. for preliminary hearing. Mr. Wysong, keep up the good work.
Thank you. February 6th.
State of Ohio versus Sean Crabtree, case number CRB 22494, CRB 24228. Your Honor, this was set for trial today, but uniform possible resolution.
Yes, Your Honor.
This is CRB 22494, State of Ohio versus Sean Crabtree. Crabtree's present with attorney Mr. Stratton. Set for trial.
Yes, Your Honor. We're going to plead to the one theft, plead guilty to that charge. And I understand the state's going to recommend 10 days suspended with 30 hours community service.
Or is it the first or the second one?
I'm not sure.
The the case from 2024, which is 24-228.
Okay.
And we're going to move to Nolly, the case 22 CRB 494. We have not had contact with the alleged witness to that, and so we're not able to go forward with that charge.
All right, on the 22494 case of Denali, that state's request based upon non-cooperation of the victim. And then, Mr. Stratton, on the 24228, what plea does your client wish to enter?
We'll plead guilty.
All right. I'll accept your guilty plea and I'll enter a guilty finding. It'll be a $100 fine. I'll order you to pay the court costs. 10 days jail, suspended. 30 hours community service. 2 years level 4 probation. I'll set you a review hearing date for July 13th at 9 a.m. And is there any restitution amount or anything that needs to be on that, Mr. Gill?
No, Your Honor.
No restitution sought by the state.
So you just need to go with probation. All right? All right, thank you, Your Honor.
Thank you.
State of Ohio versus John T. Wellman, case number CRB 24444.
Your Honor, I believe he is testing at the moment, so.
State of Ohio versus Mark Jackson, case number CRA 25344, CRB 25345.
All right, this is State of Ohio versus Mark Jackson, CRA 25344, CRB 25345. Mr. Jackson is present with the attorney, Mr. Dyer. Trying to set up the preliminary hearing.
Your Honor, the state's indicated a desire to take this case to the grand jury, and in order to possibly preserve his bond, Mr. Jackson is choosing to waive his right to preliminary hearing today.
Is that correct, Mr. Jackson?
Yes, sir.
All right, you understand you have the right to have a probable cause hearing in this court, but by waiving it, you're giving up that right?
Yes, sir.
All right. And Mr. Gilder, you're going to nominate the misdemeanor with the grand, or send the misdemeanor to the grand jury with the...
You don't work with the
Yes, Your Honor.
All right. The CRB 25345 will be nominated to the grand jury, and Mr. Jackson is going to waive his right for the hearing on CRA 25345.
And Your Honor, I'd like Mr. Heald to, as part of this, to make a note in his file to have a summons issued in the event of an indictment so that he can have an opportunity to appear on his own. Sign it here for me. Yeah. And let me ask you something. Is that well, we don't have an address for you. Can you give him an address?
It'd be 266 Guyan Avenue, that's in Huntington, West Virginia.
May I approach?
No.
And that's the zip is there, 25?
25702.
You're welcome. Lawrence County Clerk's website.
That'll be downloaded at grand jury for consideration.
Monthly. It'll be mid to end of January at the earliest. Thank you, Your Honor.
State of Ohio recall 6 Bentley, case number CRA 25359. Mr. Smith,
Judge, apparently, my client is due to be in Sauter County. There is a felony case that she is a witness in. She's been subpoenaed. I'd like to move it back to the 26th from February 9th, if if that's okay.
Yeah, we can do that. Reset the case on 26.
Absolutely.
Okay, yeah, I wanted to make sure we did that, even though she's not on screen.
That'd be fine.
Okay, thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you.
26. Thank you.
State of Ohio versus Catherine Metzger, case number PRC 253020, A and B. Mr. Moore.
State of Ohio versus Catherine Metzger, PRC 25-320, A and B.
Judge, I'm gonna have to ask you for a short continuance. We need to file discovery on the 2 misdemeanors in this. If you don't mind giving us a week or two.
How about January 12th?
I'm sorry?
January 12th?
Okay.
That's good.
All right. Defendant's request is now to be continued to January 12th for preliminary hearing and pretrial.
As soon as we get the information.
Thank you, Your Honor.
Thank you.
State of Ohio recalls Darren Cohen, case number CRB 2496, A and B, CRB 23761.
State of Ohio versus William Horn, CRB 2496, A and B, CRB 23761. Mr. Horn was supposed to be here at 9 a.m. and when we called the case approximately 9:40, he was not here, but he has appeared here at the house. All right, Mr. Horn, do you have a reason that you were late this morning?
I was here at 10 a.m. That's what time I thought it was. I apologize.
No, I won't hold that against you this time, but looks like on the CRB 2496A case, you owe $275, but there hasn't been a payment made since September. On the CRB 23761, looks like you made a payment of $50 on November the 10th on that case. You have a payment today?
I made an electronic payment and I have a $40 cash payment.
Okay, how much was your electronic payment?
25.
All right. I'll set you back for review. January 26th.
Thank you.
And we're called in one. And that's at 9 a.m.
What?
We were telling tall tales.
He's not in here, so he might be still.
He was, he came in, and then he left again.
Okay, well, we can call him. See if he's done. Do we have a test back yet on Wellman?
I'm not sure.
This thing's going.
Call waiting, Your Honor. State of Ohio versus Mike Ferris, case number CRB 25247, set for sentencing. Mike Ferris.
All right, this is State of Ohio versus Mike Ferris, CRB 25247. Mike Ferris. In Mr. Morford's case. Setting the sentence. Mr. Morford, we have Mr. Morford in the courtroom.
You say Mr. Morford left?
Well,
Not sure.
client's not here, so there'll be a bench warrant issued for failure to appear.
I don't see that there's any monies owed on that. I'm not sure if the community services been updated since it was on sentencing. It might be completed. He did work 8 hours. He was getting credit for 8 hours on 12/18.
Well, that's probably why then. Looks like Mr. Ferris has completed everything.
That is correct, Your Honor. He turned the stuff in yesterday, and I believe I finished him up. I believe there was a treatment component, is why we put him, left him on the docket.
What's with ODP last one?
We did not see a completion there.
I've got nothing else on file. I won't issue the warrant then. We're going to just reset it. And then Mr. Morford is here, I think, on the 12th. And I'll set that as a sentencing hearing at that time. And maybe we'll have some more clarity at that point.
State of Ohio versus John Guido, case number TRC 25944, A, B, and C.
This is State of Ohio versus John Guido.
Well,
Yes. Smith's case says
She did get paid.
Okay.
To the insurance. I didn't print out that email.
That's, yeah, this one.
I believe he received an email from the insurance. I did.
His insurance, this guy, she waived some money from the judge,
Oh, yeah.
but she's not here. She should be here, she didn't get to take it.
Amber Carpenter.
It was like $580. It was like $580.
What I might do is have you send that email to me, and then I can provide it to the state.
I can do it.
Oh, this is that one. I think she came on the 14th.
Send that to you, Brian.
Yeah, do that, but he's going to need to come back anyway.
Oh, yeah, but I just want to make sure that was it, that fires with that. And you send it to me, I'll forward it.
This one, in my computer.
So, THC's about to get out of your system, right? Hopefully. She tested positive here a week ago. Should be negative. So you come back next time, I guess it won't be here at all. Probably come back in a month. Should be.
Yeah, he wasn't ordered the treatment. He's there on his own accord.
Okay. The judge, he's not ordered the treatment, he's checked in on his own. There is, or was, last time we heard this, an issue with the driver who was not at fault, whether the van had been taken care of by his insurance. He did receive confirmation by email. He's forwarding to me. I will forward to the court and to Mr. Heald, so the victim of the crash is being made whole. So that's not going to be an issue going forward.
about January 26th.
Yes, I was saying this thing, we should pick a date. That one I'm here.
All right, sentencing, 10 a.m.
And I'll forward that email to the court and to Mr. Heald.
State of Ohio versus April Seabach, case number TRC 25-1892.
Judge, I sent a text with her report. It was on my client's phone. I don't know if you've received it yet, Mr. Hill. OVP out there. It's on her phone. Should be in the messages.
All right, this is State of Ohio versus April Seabach, TRC 25-1892.
Yeah, I sent it to you and Brian.
Maybe she's a spy.
All right, good report.
Doing well, Judge. When do we come back, type of situation?
January 26th.
Sure. That'll get it for you. January 26th.
This is what you've done.
Did you complete MVP?
I don't know how long I'm supposed to be there.
We just don't put this one, we'll come back the 26th. I'll be with OVP and find out.
I'm permanent.
In which court?
It's Leanne.
Wausau, that's Judge. Iron Duty.
Why can't I get in my computer? Was she on the Oh, 16. Yeah, she's on her seat. Oh, I think you must have that file. Oh, no. Why is that here? I don't know. Oh, that's his own file he made.
126 at 10 o'clock. And I see you about it. I'll reach out to her. January 26th. Yeah.
10?
At 10. Six 26 and 10. You got it. And I'll talk to Lee.
State of Ohio, John Wellman, case number CRV 24444.
All right, this is the State of Ohio, this is John Wellman, CRV 24444. This is Mr. Stratton's case at trial today.
Bill, THC, that's it, on the insurance. Okay. That's how the sense of that.
So, the screen was good?
THC's on.
Yeah.
He got a card for you.
Not a problem. So, you want to see if she'll get out? But, very approach.
Yeah.
No, the report was good. Report, yeah, he has a copy of the report, so. Oh, yeah, we're aware of that.
Oh. This thing's going around, right?
Huh? And then we'll plead to discharge, and then I'll suspend the time with probation, okay? Well, there's always probation, but in the case, there's going to be probation. But you're doing well in treatment.
Approach your own.
Suspend the jail. You still be on paper. But it'd be like a non-reported probation. You ask me the was, which one more probation. Your attorney.
And it's somewhat reflected in the report, but again, it's not really an assessment. I can order her to do it. Maybe that's too much stuff.
Okay. And it's just a matter of figuring out what the counseling would be, where it would be, and what it would entail.
So,
Well, you can't be, it would be a voluntary thing. But it probably would be.
so she's going to agree to counseling. Okay. All right. And then we're going to agree on this. We're going to plead guilty on this case. Okay.
Your Honor, I've been speaking with sorry, I forgot your name, Claudette Gibson, the alleged victim in this matter, and it's my understanding that Mr. Wellman has said that he thinks that Claudette Gibson should also do some counseling, although the court can't order her to do the counseling, but that would be one thing that would be contingent upon her agreeing to do in order for Mr. Wellman to enter a guilty plea to the domestic violence charge. They continue to live together, and it sounds like they're going to continue to live together, and I think it's a good idea. If there would be counseling that would involve both of them together, Ms. Gibson's recommendation, her idea is that they would go to Shawnee. I think she feels comfortable with them. She's used them maybe in the past.
I used RRS.
So I don't know how that fits with his current RRS. Can he do both?
He's comfortable with RRS because that's who he's been going through and been doing well with. Why don't we do this? Why don't we enter a plea, set up for sentencing, and just keep track of how they're doing?
Well, why don't, instead of that, because I mean, here's my concern, is I don't want Mr. Wellman entering a plea on something that is contingent upon Ms. Gibson doing, and then Ms. Gibson not following through on that. And so, I know you're here on January 30th.
Yes.
Why don't we set this for January 30th as a sentencing hearing? That way, that'll give Ms. Gibson an opportunity to get lined up with it, show that, hey, yeah, I've done this now, and at that time, I would feel more comfortable taking the plea than today, just in case something came up and it didn't happen. I wouldn't want Mr. Wellman feeling like he was, misled by anybody in doing so.
Okay. All right. Sounds good, Your Honor.
Mr. Field, an opportunity.
you don't have to agree to do this at all. Okay. Okay. When are we approaching it?
Okay. Well, we set for trial on Monday, then. Works, it works, if it doesn't, I don't know what I'm gonna do, I'm really confused. And I'm not getting into, that stuff matters as far as it matters to me. I mean, you got one there, no big deal. At the end of the day, but, well, we just have to try that.
Well, let's do it first. Let's see what happens. And if she wants to go recount it, which may not will, then
I would just hate for him to enter a plea thinking something voluntary is going to happen, and that not happen, and that's why we're done.
Well, how about this? Withdraws plea.
yeah, I don't think we're in a position to control it. I don't think that rises to, I don't think it's one of the reasons to withdraw it.
Sure, well, I mean, it's before sentencing, it's just the interest of justice. Nothing on the record that says that's going to be taken into consideration. I think that that's a pretty good legitimate reason to withdraw it. Yeah, I don't know if that's right. Okay.
It's not nothing my experience on withdrawal,
Well, typically, my position is anytime he agrees to it, or agree to do it, but, yeah, oh, well, I would be down to 30. Okay.
You can do the election yourself. You decide that you're an attorney, and you get it in your house. Okay? For your own little bit. It's happening once. Okay? And that's all the opportunity you really for this to do. Okay? All right? Because I'm smoking enough, but she's going to do that second time, and she's going to be staying in your house while you're staying in a cardboard box under the bridge. Do you know that?
So I can go down.
Yeah. Because I've seen this kind of thing before. Okay. When you tell you that you are in a position she was, that she's just using you, okay, for place to stay, they create situations where charges against the guy, and then they look at your contact order, like protection order, get the guy out of the house, and you're staying in the guy's house, and the guy's residence. The guy's staying out on the street. Okay? All right? And it sounds like that this is headed down that direction. This is for you. This is about her. This is about you.
Your Honor, if it pleases the court, I guess I've made the leap to saying that they needed to do counseling together. They don't necessarily, he just thinks that she can benefit from counseling and they're living together. So even though she wouldn't be able to be ordered to do that, she'd agree to go to counseling. She likes Shawnee. She'd go to Shawnee.
Okay, that's fine.
Okay.
Let's see, so let's come back on the 30th and see how that's progressing.
All right, do we want to set it as a trial or as not a trial officer?
Pre-trial. Well, since she's agreeing to do it, I mean, I would think we could accept the plea today.
Let's say that's pre-trial, Your Honor.
I don't know that I would be fine with accepting the plea with the understanding that the state was agreeable not, in the event that the counseling didn't happen, to allow it to withdraw. But I would also think it would probably be just as clean, or probably even cleaner, to set it as a pre-trial on it. But
That's fine, Your Honor.
okay.
State okay with that?
I don't know. I don't know what to think about this. I don't know what's, obviously, Ms. Gibson is not subject to court orders on this. It's a voluntary thing on her part. And I don't know what would be expected of her to show something on January 30th that, you know, she's in counseling. I mean, I don't know what it would, when we get there, what objection's going to be made if it's not according to what Mr. Wellman expects.
Well, here, let's just do this. We're going to set it for trial on January 30th. I'll be here. Set it at noon. And if we have something sufficient that satisfies everybody, we'll resolve it. And if we don't, we'll have a trial and we'll resolve it.
Yes, Your Honor. Sounds good to me.
All right, thanks.
Thank you.
All right. You understand, don't you? All right.
See you in January.
State of Ohio versus Kiefer Wilson, case number CRB 25-416 AD&C, CRB 25-62.
All right, this is the State of Ohio versus Kiefer Wilson, CRB 25-416 AD&C, CRB 25-162. Mr. Stratt, set as a sentencing order.
January 30th. This is the, Wilson, that's a termination of the attachment. Was it on there? Okay, I'm sorry.
Okay. All right, so let me ask you something.
Yeah.
This is a circuit release.
Yes, he said he was gonna bring it up.
He pled for the domestic violence charge. Rest of the charges pending will be dismissed. We advise the victim to get the case number to resentence, to get sentenced. He wants to be able to work, to discuss things in outpatient. All right, so how's he doing the treatment?
He's done well.
It's like my password's in
The protection order has been terminated in this case.
The civil protection order has been terminated. Just see how the state wants to proceed.
All right, now I need his file. All right, sounds like he's still taking part in treatment with RRS. There's been maybe a minor setback, but he's still in the process.
Keep an eye on outpatient service.
This case began with several different charges, a violation of protection order, and then a domestic violence, and another violation of protection order, and a paraphernalia charge. And he did plead already to the domestic violence charge, and we agreed that we wanted the protection order, that the violation of protection order charges were based upon, to be dismissed, because we were told by our victim that they were doing that, in the process of doing that, and we've been presented with an entry that shows that it was dismissed. So we're okay with dismissing the rest of the charges, and we would also be okay with Mr. Kiefer Wilson to continue and complete his treatment with RRS under the domestic violence conviction.
Okay. So are you indicating that you want to come back on the domestic violence, or go ahead and sentence on the domestic violence?
Well, you could, yes, that would be okay too. One of the terms.
I'm not sure what everybody's referring to here.
And that would be fine. As one of the terms of his sentence, we wanted to complete his treatment with RRS. We're not asking for him to go to jail, but we'd ask for a suspended jail sentence.
Okay. All right, on 25416A, my understanding is Mr. Wilson has already entered a plea of guilty and was found guilty. It'll be a $100 fine. I'll order him to pay the court costs. 30 days jail, 30 days suspended. $30 hours community service, 2 years level 4 probation. He has to continue his treatment with RRS as a term of his probation. And the remainder of the charges, the 25416B and C, and 25162A will all be non-state requests.
Okay.
There'll be a review hearing set for July 13th at 9 a.m.
So, go over probation, okay, and talk to them before you leave. Yes, sir. All right.
Thank you, Your Honor.
State of Ohio versus David Akers, case number TRC 20-2197, A, B, C, and D.
This is State of Ohio versus David Abrams, TRC 20-2197, A, B, C, and D. Says, it's a good report, Mr. Abrams.
Yes, sir.
All right, I'm gonna set you back for January 26th.
26?
Yep, 10 a.m. for sentencing.
Yes, sir.
You're pretty good. Thank you.
Thank you. Have a good day.
You too.
State of Ohio versus Rodney Dale Clay, case number CRB 25738, State of Ohio versus Christie Clay, case number CRB 25737.
All right, State of Ohio versus Rodney Clay, CRB 25738, and State of Ohio versus Christie Clay, CRB 25737. Matter says assent in here.
Okay. Okay. Thank you. Your Honor, if it please the court, previously, this is a cross-filing, obviously, and previously both Mr. and Mrs. Clay agreed to go to RRS for some counseling, and it's my understanding, been told that they were assessed for substance abuse issues and found to have nothing that would indicate the need for counseling, and that they took part in some mental health assessment and some sessions and felt that they were cleared on those issues as well. Now, they both pled guilty previously, and they've not been sentenced. And I guess what we would want to inquire about this time is if they've had any other problems, or if their things have settled down. And
no problems?
No problem, sir.
we'd be okay with dismissing both of their charges, Your Honor.
All right, state's request, these matters will be dismissed.
Thank you, sir.
There you go, thank you.
Thank you, sir.
State of Ohio versus Raymond Wall, case number TRD 23530, A, B, and C. Raymond Wall. Is that your sentences?
All right, this is State of Ohio versus Raymond Wall, here in 23530, Time 22 p.m. Mr. Wall is scheduled to be here at 10 a.m. He's scheduled to appear. And so there'll be a bench warrant to issue.
State of Ohio versus Amy Van Zandt, case number CRE 25458 A and B, CRC 25830, CRB 25456.
State of Ohio versus Amy Van Zandt, CRA 25458 A and B, CRC 25430, CRB 25456. And my understanding is Ms. Van Zandt showed up today. Looks like this matter was set for January 5th. These matters were, Van Zandt is here today, and I'm not sure why.
Well, I was told by Gary Sowards wanting to go ahead and come in today because it's totally my fault. Apologies to the court. I was thinking it was Friday. I had to be here today on my birthday, but it was the 15th, Monday. So I do apologize for that, but he did tell me to go ahead and show up today. And, my bond would still be valid.
She didn't appear on Monday.
Okay, on the 15th? Okay, yeah, Mr. Smith's case. I think Mr. Smith may have already left. Okay, well, here's what I'll do. I'll recall if there's any warrants that were to go out, I'll recall that, and I'm going to set you back at the original scheduled date of January 5th.
Thank you.
And the bond will continue.
State of Ohio versus James DeVent, who's back in Holden, Your Honor. Case number CRA 24290, CRB 24635. CRA 24786, CRB 24787.
All right, this is Stable Heights, James DeMint, Sierra 24-240, Sierra 24-685, and Sierra 24-786, Sierra 24-787, A and B. Mr. DeMint was taken into custody, from my understanding, as he self-discharged himself from hometown recovery. Is that correct?
That is correct, Your Honor.
Okay, we'll read the report here. What's the date, right?
The 15th.
Your Honor, he did leave there, but he immediately went to the Recovery Ranch, another representative working there today. He did inform Mr. Sowers, Gary Sowers, about it, who he's currently on bonds with. And Gary indicated that he was fine with it, not necessarily leaving, but going, that he left and that he went to this other farm, like I said, he was okay with it. So, Your Honor, I asked that we be allowed to go to this new place. I know there's some issues that we had at the prior rehab, which we could probably see.
Well, first off, would hometown take him back?
We will, Your Honor.
Okay. Well, I'm not interested after reading the report, and quite frankly, Mr. DeMint, you don't get to choose where you're going to go to treatment. If you do something wrong, that is not acceptable. The report itself said that you had, now I was encouraged that you did, you wouldn't take, I was not encouraged that you wouldn't you submit to the urine screen. However, you did indicate that you wouldn't pass because of an affair. So you did own up to that, but, you had indicated apparently that you could not afford to be placed on a behavior contract because there's the restrictions of that. And you don't then get to go shop and go somewhere else to where you don't have those restrictions. So, or you've got two options here today. I'll give it to you straight. You can either agree to go back to hometown, and I'll leave it up to you. If you don't want to go back to hometown, you're more than welcome to not do so. But you're going to be in jail if you don't. So you can choose jail or you can go back to your treatment. Which do you prefer? Okay. I'll order you back into treatment. I'll leave your bond in place, and you'll be released to hometown for treatment. Okay?
Your Honor, given the circumstances, I think the security of a ankle monitor might be appropriate.
Well, I don't know that we have one.
I don't know if that's necessary.
I don't know, Your Honor.
We got something better than an ankle monitor, Your Honor, that's very sound.
He does have a bondsman there, and what he had indicated that he had taken at that time was a non-narcotic pain medication. So I'm going to leave the bond as is, mainly because he did at least make the effort of checking himself into another rehab facility. So I'll give him that benefit from that perspective, but you don't need to shop. You order in hometown, that's where you're going to be. Unless there's some indication that there was some problem that occurred that was not of your doing.
But the night before, I was threatened by another client that he was going to bust my head and stomp my ass on the floor.
Well, that was not in any of the report. Was there any indication that ever occurred?
I'm not aware of that, Your Honor.
They had in front of two staff members. I was sitting in a group. I did the next morning is when this drug test came about. But I was sitting in case management, double case management, like me and this other guy was at two staff members was sitting right across from me. It was mine and his. And we was all in a mutual conversation, and I did say something I should have probably said.
Okay, that's enough right there. I don't want to hear any further then. You said something you shouldn't want to say, and again, you know, you said this happened in front of staff members, and I'm confident that they'll likely flush that out, but I'm stop, or you're gonna go to jail. Do you understand me? I don't buy anything that you're telling me, Mr. DeMann. I don't. So, take your pick, treatment or jail?
Treatment.
All right, that'll be the court's order. You can go back to treatment at hometown, I'm gonna leave your bond the same. If you leave treatment again, you're gonna be in jail. Do you understand me?
Yes, sir.
No questions, it's not gonna be, oh, we'll let you go back and get an ankle monitor. I've had enough. You've got plenty of cases out there, and you need to take this seriously. Do you understand?
Yes, sir.
Okay, that'll be the court's order.
Thank you, Your Honor.
We'll see you back.
That's that.
Mr. Stratton, are you here the 12th? How about the 16th? All right, we'll have you back January 16th. On all cases.
He's gonna go with you right now, because Gary's trip is over, whenever we ran.
All right, court's adjourned.
You're gonna take him to the South White House and just drop him in.
No, we just drop him off there. And
Yep.
what about his truck?
We'll figure it out later.
Just go back there right now.
Thank you.
You stay loose and I'll come get me.
She was in a veggie store. It was going to say something.
Good to see you.
I felt like 1960s.
It's still on.